Yeah, my lordship. Regarding item number 50, my lord, we are appearing for the respondent number 1 and 2.
Right.
The paper book could not be served upon us because some difficulty that we later appeared. We went to the department. Since the file is here, my lord, they have asked us to mention this matter so that they can give the supply the paper book.
Paper books are lying with the department or have come here?
Lying with the department. They have taken a note here that they are lying in the department.
There's no difficulty in your getting the paper books.
We have asked them to supply the.
To verbally tell them that we have granted leave. If they still don't do it, mention it too. If they still don't do it, verbally tell them that we have granted leave. Yes. Yes.
Lordship, may I be permitted to mention for correction upon notice I am mentioning?
Action of division bench matter?
Yes, Lordship.
No, we can take it up only after the vacation. Come back after the vacation. We are sitting single tomorrow. Yes.
May I be permitted to mention, my lord, item number 90 of today's list?
Yes,
my lord.
90.
My lord, can it be taken up today, my lord, subject to your lordship
Why?
convenience at any time? My lord, the urgency is that, my lord, this is an appeal from an order refusing my identity order in a partition suit, my lord. The respondent.
You have a caveat. There is a caveat.
Lord,
If there's a caveat,
probably
give notice. We'll take it up at 2 p.m.
2 p.m. Grateful. Grateful.
Inform the other side.
I shall.
Evening 2 p.m. চলে আসবে। 2 p.m. time. Yes.
I'm praying for a leave, my lord, to file without a certified copy, my lord. The order was passed on 22nd of April, my lord. Immediately the certified copy was applied for, my lord. It's from Alipur Court, my lord. Sometime.
The matter is appearing in the list.
No, my lord. I'm praying for a leave, my lord, to file without the certified copy. Not in the meantime, I'll procure the certified copy and submit it, my lord, before the record.
Certified copy. This is a second appeal.
First appeal, my lord, matrimonial suit.
Without certified copy, we would have server copies.
Yes. Yes.
Where leave is granted.
Great.
My lord, this appeal under Motor Vehicles Act, my lord, is perhaps wrongly appearing in your lordship's this note. It is to be taken by honorable single bench, my lord.
All right. It is pointed out by learned counsel. Yes. So what? Learned counsel for the appellant submits that the matter is wrongly appearing before this bench and ought to go before the learned single judge having determination. Accordingly, let the matter be released with liberty to the parties for to mention before the appropriate bench having determination for inclusion in the list.
Obliged, my lord.
Next. Follow the next matter. Yes.
Your Lordship, in this matter, your Lordship disposed of the matter.
Right.
Your Lordship has recorded in the petition that plot number, kindly come to page 3 of the order.
Yes.
Paragraph 11. Plot number 1207 comprises of 8.42. It's not that. Because your Lordship, in the gift deed which was handed over by Mr. Mukherjee on the last date, I did not have the copy of the gift, and now I have got it. There are 8.42 acres of land. There are several plots. Total was gifted 8.842 to Mahapatra.
The total plot 1207 is not comprised of 8.42?
No, 1.51. That is in the gift deed itself. That is the.
Then you file a formal application for correction. That will pertain to the merits of the case. Please file a formal application. Give a copy to Mr. Mukherjee. We'll correct that. Next. Learned counsel.
All the,
yes, you can annex the relevant.
Yeah, gift deed.
Gift deed. Learned counsel for the respondent number 1 seeks a correction to the judgment dated May 14, 2025, insofar as the area of plot number 1207 is concerned. Liberty is given to the respondent number 1 to file an appropriate application for effecting such correction. Upon giving an advance copy of the same to the appellants, liberty to mention as and when such application is filed.
Let's say I beg to appeal on behalf of the respondent bank. Let's
Is that
But
matter?
I appear for appeal.
Let's see.
Yes, yes,
In,
yes.
in view of
Yes,
the
only
lordship
one.
direction we have served, we have mentioned the matter. Your lordship daughter intends to visit Mumbai.
What
for-
was the direction we passed previously?
Previously, your lordship, there was a direction to visit every Saturday at 4 o'clock.
You are the
I'm the husband.
husband, daughter is with you,
Daughter is with me.
is with you.
Now the husband is working in. Initially, he
She
was
wants to go for the vacation
in Mumbai, where the father is working
for
in
what
Mumbai.
period?
For a period up till 7th of June, because her vacation is ending there. Thereafter, she will return and continue with the order of the
What is the age
Honorable
of the daughter?
Court. 12 years.
Yes, my lord.
Thank you
One
so much.
thing, my lord, with your lordship's indulgence,
Yes,
my lord,
yes,
I
yes.
my lord, the girl is, my lord, the daughter is, my lord, 12 years old. She is undergoing, my lord, various biological changes, my lord.
Definitely.
Matter was appearing, my lord, under the heading here for hearing, my lord.
It
And,
will
my lord,
go
my
back to
lord,
hearing.
My lord, the other High Court and my lord, Apex Court also held, my lord, at this age, my lord, mother should be given accomplice.
That is the
Lordship
purpose
may
of the
dispose
case
of
now.
my appeal, my lord, only on this point, because there is nothing other point, my lord, which need to be gone into, my lord.
No, no,
Lordship,
when we hear the matter.
Only
Now
when-
they're only wanting to take the daughter for the vacation to his home,
Lordship,
to her his work.
only my lord, lordship will give some preference for the hearing, lord. Only
Not right.
this
We
point,
cannot
my
consider
lord.
right now, no. Learned counsel for the respondent submits that the minor daughter of the parties, comma, who is aged about 12 years and in custody of the respondent father, seeks to go and stay with her father at his working place in Mumbai during her summer vacation. First up, it is submitted that the daughter shall duly return to Kolkata on June 7, 2025.
That's it, on June 7, 2025.
On June 7, 2025. First up, next para. Learned counsel for the appellant mother, comma, in his usual fairness and on instruction, comma, submits that the mother does not have any objection in principle to the same. First up, learned counsel for the appellant seeks an early hearing of the appeal. First up, for the present, comma, since the matter is appearing under the heading to be mentioned, comma, we grant leave to the respondent father to take the minor child to his quarters in Mumbai, and to return the child to Kolkata on or before June 8, 2025. First of next para, it is made clear that the earlier order of visitation shall continue thereafter as directed previously. First up, the appeal shall be placed in the hearing list immediately.
Obliged.
After the vacation mentioned, we shall consider whether we can
Lord,
take it up early.
Much great, lordship.
Obliged, your lordship.
Thank you. Yes.
Me, please, Lordship. This is my application for visitation, my lord. Your lordships on March 10, 2025, my lord.
Can one or can two, Mr.
My lord, both are pending. My lord, I have filed the application pursuant to the leave granted by your lordships, my lord. The can two. My lord, since I have prayed for modification of the order, your lordships, my lord, direct me to file an appropriate application.
Yes.
My lord, can two is that application for
What was the
modification.
original order?
My lord, original order is, my lord, the daughter was directed to be produced on every Saturday at South City Mall from 5 p.m. to 7 p.m. Now, my lord, on the immediately after passing of the order on 10th March, my lord, the first Saturday, the child was produced at the right time at 5 p.m. Thereafter, on the next Saturday,
Yes,
the-
you recorded in your earlier order.
yes, yes.
Last occasion, your lordship was asked to furnish the current address of the respondent, my lord. Here it is, my lord.
Give it to them. Mr. I will give you liberty to amend the memo also, adding this address. It will be an additional address, not in place of the previous. Now she's residing where? Ma'am,
Now, my lord, it's
where is she
appeared-
residing now?
My lord, it's
Use the microphone, please. Use the microphone. Barashat.
Barasat, my lord.
Yes.
No, my lord, I think my learned friend is not
What
correct
is
on the
the
subject, my lord.
address there?
The Priyanka Gupta, daughter of Gautam Sen Sharma, age about such and such,
Address?
residing at 332 Nilachal, which is the address of the appellant.
No, my lord, kindly consider, my lord, where the licensor and the landlord is the sole owner of the plot, which is in Barasat, my lord, and she is.
This is the address, my lord, that has been
Let us see
mentioned
that.
in the agreement.
দিন তো ওটা।
Is a
এই এসিটা বন্ধ।
given license agreement, my lord, the address that has been given at is of 332 Nilachal. That is the address of the appellant.
Why did you violate the order of the court without any modification previously? We had specifically directed you to produce the child at a particular place. Why did you violate?
My lord, on second Saturday, my lord, with prior.
Did you take leave of the court? We had specifically directed you to produce the child. Why shouldn't you give the custody of the child to the father? Because of your non-compliance of the court's order. There was a specific direction passed in your presence where we directed the child to be produced in a particular place regularly. The child was not produced. No application was filed by you for modification. Why shouldn't you immediately grant custody to the father for non-compliance of the court's order? And then show all your recalcitrance to the court. You have to obey the order of the court. Instill this in your mind of your client.
Definitely, my lord.
Why haven't you? What's the explanation? Ask her to stand up. That seat is reserved for advocates. And ask her to go behind. You have not called her. Ask her to go behind. Ask her to go behind. Please ask her to take her seat behind. Her place is not here. Why didn't you comply?
My lord, on second Saturday, my lord.
Second Saturday, fourth Saturday. We shall not modify the order. Unless you comply, we will see after the vacation, we'll keep the matter immediately after the vacation. You have to comply regularly, no change of visitation. If you fail to comply even once, we are telling you, we'll grant custody to the father. Whatever be your excuse.
My lord, may I submit?
Yes, what is your application for?
My lord, since the child was not produced, and my lord, on the first occasion, I also, my lord, prayed that the grandparents are senior citizens. They want to see the granddaughter. Now, my lord, your lordship.
What is the age of the child?
Age is, my lord, 7.5 years.
She's a girl.
Girl, yes. Now, my lord, on that occasion, your lordship says, now for the time being, only father should be allowed to visit the child, and your lordship will be considered afterwards. Now, my lord, in this application can 2, my lord, I have prayed for, my lord, that since the grandparents are, my lord, senior citizens and they could not see the child for 1.5 years, my lord. So, my lord, on last Friday of every month, the child should be handed over to me from after the school hours, and I shall return the child at 5 p.m. on Sunday. That I have prayed for. In the can 2.
This address is at Barasat, Mr. Rai. Here her original address was shown, where the party description is given, but this shows that license has been given to her at Barasat.
Yes, my lord.
Well, initial
address, because when the license was entered into, that was her address. Now she has entered into this.
Well, may I see when the license has
Yes,
been entered into?
Yes, check up. You ought to have had extra copies of this, 2 for the court and 1 for them. You are so stingy, you are saving on copies also of a 3-page license agreement.
Well, the agreement is on dated 1st December 2024. Well, at that time, she was not residing in at Nilachal, Birati. Anyway, let's see.
When did you pass the order? When you passed our order, she was residing there.
Your lordship.
So why is this relevant?
Because
she has taken a plea that she is not being able to.
Yes,
no, she'll bring the child wherever she was bringing. Where did we direct? South City Mall.
South City Mall.
5 to 7. Can it be somewhere in between, Mr. Rai?
Well, I do not have any objection.
Right now, we don't want to penalize her by giving the weekend visitation.
No.
We'll keep the application immediately after the vacation.
Well, I do not have
ad hoc basis. Let it be somewhere in between. Where do you live?
Well, I live in Birati. She lives, according to her, that she lives at Barasat. Let it be in between there in
Virati
any,
Barasat is close by. So
yes,
suggest a place,
My lord, within Barasat at anywhere.
not within Barasat. She'll have to come to Virati with the child. Virati, suggest a place. Ask your client. Ask your client and suggest a place. Mr. Roy, you can help them. You can ask your client also.
Sun City Mall. My lord, Sun City Mall at Barasat.
Barasat, no. Virati, yes.
city center 2. City center 2 to Salt Lake Zero.
But during the vacation, let her be with the father. After vacation, we'll consider. Can 2 of 2025 has been filed by the appellant father seeking a modification of our previous order by which we directed the respondent mother to bring the minor daughter of the parties for visitation by the appellant father at the South City Mall every Saturday between 5 and 7 p.m. However, apart from one occasion, the child was never brought for such visitation. On another occasion, the child was brought late. That apart, the respondent mother has consistently abstained from producing the child for visitation by the appellant father. Next para, we find from the records that no application or prayer was made by the respondent wife for alteration or modification of our order, whereby we directed the child to be produced for visitation at the South City Mall. When the matter was mentioned subsequently by the respondent, by the appellant father, the respondent mother seeks to take a plea that since she is now residing at Barashat, it was difficult for her to bring the child to the South City Mall on every such occasion. Next para. However, we strongly deprecate the recalcitrant attitude of the respondent mother who, despite knowing of the specific order of the court, has flouted the same nonchalantly without caring even to seek for a modification of the said order. The respondent mother took it upon herself to decide as to whether or not she would comply with the order of this court, without bringing to the fore the problem, if any, being faced in visitation of the child at the South City Mall. Next para, the learned senior advocate for the appellant father submits that on the last occasion, the appellant's parents, that is the paternal grandparents of the children, also express their desire to meet the child. As such, it is suggested by the appellant that the child be permitted to be taken by the father to his residence over the weekends and be returned to the mother thereafter on every weekend. Next para, we are also apprised that the appellant father is residing at North Damdam, Birati, whereas the respondent mother admittedly is residing in Modhomgram at present. Next para, hence, it would not be difficult for the mother to travel the short distance from Modhomgram to Birati for handing over the child every weekend to the appellant father. Accordingly, we modify our order dated March 10, 2025 and direct the respondent mother to bring the child every Friday, starting from May 23, 2025, that is tomorrow, in the evening at around 6 p.m. to the residence of the appellant father and hand over the child to the appellant father. The child shall stay with the father's family over the weekend full stop, the appellant father shall return the child to the residence of the mother at Barashat, within bracket Madhyamgram, on the following Sunday at around 10 a.m. Full stop. This exercise is an ad hoc arrangement which is being formulated by the court for the time being, comma, subject to final disposal of Can 1 of 2025 and Can 2 of 2025. Full stop. Next para. It is made clear that such arrangement shall continue until further orders. Full stop. Next para. It is further clarified that we are not confident of the trust of the appellant respondent mother in the orders of the court and or the obedience of the orders of this court by the respondent mother due to her past conduct, full stop. Hence, comma, in the event we find that the above directions are not complied with until further orders, comma, the court shall consider handing over the custody of the minor child to the father, appellant father, during the pendency of the appeal. For sub next para, both the applications shall next be listed on June 16, 2025.
And one more prayer from him. Your lordship already directed me to file the paper books. And I am praying, let it be extended till 30th June. It is under preparation.
The time on the prayer of the learned senior advocate appearing for the appellant, comma, the time for filing paper books is extended till June 30, 2025. এটা অ্যাপ্লিকেশন হেডিং এই দুটো আসবে 16 তারিখ। নেক্সট। Yes. What is the matter about?
So this is refusing to extend the interim order of injunction. If your lordship can, previously the suit for specific purposes of contract, in such a suit the plaintiff is the appellant before your lordship. Initially, an interim order of injunction was refused came before this honorable court. I am drawing lordship attention so for the order passed by this honorable court, page 19 of the application. My lord, if your lordship is kind enough to take the application, page 19. My lord, got it.
Yes.
Now, I am drawing lordship attention, page 21, paragraph 5, 6, and 8.
Appeal was admitted formally.
Admitted and injunction was granted. That is why, my lord, paragraph 6. We therefore restrain the defendant's respondent from transferring and encumbering the portion of the subject property which has not been encumbered as on this day in favor of third party for a period of 4 months from the date or until further order, which was earlier. And the learned trial court was directed to dispose of the same within a period of 1 month. My lord, got it? That is at paragraph 8. These 4 months will expire on 15th. That's why I filed an application for extension of the.
Will expire when?
On 15th. 15/5 it will expire. I filed an application for extension with the court below because the
15/5 means it has already expired.
now expired. Before expiry,
You
I
have filed.
filed an
So
application.
now what?
Now my lord can turn to the order impugned.
This application is in a dispose of appeal.
No, it's separate because refusing to extend the interim order injunction by the court below. That is why it's separate.
Achha, achha. Oh, no, it was for 4 months from that date.
For 4 months from that date, with the condition that the trial court will dispose of the same within a period of 1 month.
The 4 months is elapsing on 15th.
Already elapsed on
15th.
That is why on 15th, my lord, this is the order passed. My lord, what is
Why is the injunction still pending?
It is not.
Court is heavily pressed.
My lord, we have already filed our objections to the injunction.
Will extend for a further limited period and direct the
My
court
lord,
to
I've
do.
just received the copy to yesterday only, and direction that it has been
Though it is not.
listed today. I have not
As my learned friend was there.
obtained
Very
instruction.
that's
My
why.
lord. My lord, kindly list it after vacation.
We'll list it after the vacation. For the time being, we are granting injunction. Otherwise, they'll be without injunction. And that was already granted by the coordinator.
And it was held.
If you agreed, we could have disposed of the appeal.
That is
Anyway, let
precisely-
us come back after the vacation, take instruction.
That is precisely what my intention is. The court is of the opinion that I cannot extend the issue.
The brief history of the present appeal is that initially, comma, in a suit for specific performance filed by the appellants, comma, an ad interim prayer of injunction was refused by the learned trial judge, comma, against which an appeal bearing FMA 852 of 2024 was preferred. Full stop. A coordinate bench of this court, comma, vide order dated judgment and order dated January 16, 2025, comma, disposed of the appeal along with the connected application, thereby granting injunction restraining the defendant's respondents from transferring, comma, alienating and stroke or encumbering the portion of the suit property which had not been encumbered as on that date in favor of a third party for a period of 4 months from that date, within bracket, which has elapsed on May 15, 2025, bracket closed. Full stop. Simultaneously, comma, the learned trial judge was requested to make endeavor to dispose of the main temporary injunction application within 1 month from the date of expiration for the period of exchange of affidavits. Full stop. Learned counsel for the respondent submits that the affidavits, the written objection of the respondents has already been filed in the learned trial judge. Full stop. However, comma, the learned trial judge has not yet been able to dispose of the injunction application even after the lapse of 4 months instead of the 1 month as intended by the coordinate bench of this court. Full stop. Accordingly, comma, the appellants, plaintiffs stroke appellants sought an extension of the interim order granted by this court, which was refused by the present impugned order on the ground that this court had not directed the learned trial judge to extend the order of injunction passed by this court. Push up next para. We find that in view of the failure of the learned trial judge to dispose of the injunction application within a month as directed, comma, the refusal to extend the injunction order was not justified. Full stop. In any event, comma, no specific leave is required from this court to extend the ad interim order, comma, since the initial refusal of ad interim order by the trial court merged with the judgment and order passed in FMA 852 of 2024. Full stop. Hence, comma, since there was a prevalent order till May 15, 2025, comma, the learned trial judge had sufficient jurisdiction to extend the same until a further date and or till disposal of the temporary injunction application. Full stop. Next para. Thus, comma, we find that a strong prima facie case has been made out. Full stop. Accordingly, FMAT 194 of 2025 is hereby admitted and shall be heard on the grounds taken in the memorandum of appeal. Full stop. There shall be the respondents and or their men and agents shall remain restrained by an order of injunction from transferring, alienating and or encumbering the portion of the suit property which had not been encumbered till May 15, 2025 in favor of any third party for a further period till June 30, 2025 or until further order, comma, whichever is earlier. Full stop. It is made clear that nothing in this order shall prevent the learned trial judge from disposing of the injunction application itself. Full stop. In the event the temporary injunction application is disposed of in the meantime, comma, the tenure of the order granted by this court by the present order shall automatically expire and merge with the order passed in the temporary injunction application. Full stop. The learned trial judge shall proceed unimpeded by any of the observations made herein on merits and shall be at liberty to dispose of the injunction application on its own merits without being influenced in any manner by the ad interim order granted by us. Full stop. Next para. The application shall next be listed on June 16, 2025 for passing further orders. Should we direct affidavits in the meantime? We think the appeal itself can be disposed of.
I just take instruction in the meantime.
Already it will only for the purpose of extension of the trial.
Your learned friend is fair enough. I mean, on the exception, he's yes. Yes.
My lord,
Mr. Ghaffar, what is that?
my lord, I am the plaintiff appellant before your lordship.
Yes.
Coming before your lordships, my lord, against the refusal to grant an ad interim order of injunction, my lord, at the first stage. May I indicate the facts, my lord, before I
No
take your
caveat is
lordship?
there.
Okay, wait.
Very good.
Now, may I indicate the facts? My lord, I had purchased the portion of the suit property because I had approached the defendant and the pro forma defendant, who are the brothers and co-owners of the suit property. Now, it was agreed that each of the brother would be selling me for 3.4 crores, their share of the suit property. One of them, my lord, being the defendant.
How many brothers?
Two brothers. Two brothers co-owners. Now, my lord, one of them
One is the defendant, the other is the
is the pro forma defendant who sold it to me already. The pro forma defendant had sold the property
Obviously,
to
yes,
me.
that's why he's pro
Yes.
forma.
And thereafter, my lord, on a better price being offered, the defendant has now written a letter not to me, but to the pro forma defendant, his brother, that look here, you purchase it in 5 days, else I will create a third party interest. My lord, there are several letters.
Was
whereby-
there any written agreement with you?
My lord, no agreement, because the deed of conveyance, my lord, one of the co-owners, the 2nd December 2024, the deed of conveyance mentions in the Schedule A property the entirety and the 50% undemarcated share with me in the
No,
the
your
schedule.
cause of action now is against defendant, number one.
Is against the defendant.
So,
my lord.
was there any written agreement with the defendant, number one? If there is no written agreement, then how can you?
My lord, the demand draft was in fact prepared.
But
in
the
favor of
agreement was oral.
oral agreement, but the demand draft is there on record, my lord. And thereafter, your
You
lordship would
produce the
also
demand draft along with your injunction application in the
yes,
court.
yes, yes. Your lordship would kindly see the demand draft is appearing at page 124, my lord.
All the demands, 4-5
The demand drafts are there, several
The
demand
only
drafts.
reason given is that without hearing,
My lord, your lordship would now, may I draw my lord's attention to page 19.
there is a
which
demand
is the-
draft.
This is the impugned order.
No, we have seen the impunity.
My lord, my lord.
Yes,
Demand
we'll grant
draft,
injunction.
my lord.
The present appeal has been preferred by the refusal by the trial court to grant ad interim injunction in favor of the plaintiff stroke appellant. Push up next para. Plaintiff stroke appellants. Push up. Learned counsel for the appellant submits that a verbal agreement was entered into between the defendant stroke respondent number one and the pro forma defendant stroke pro forma respondent number two to sell their respective shares of the subject property to the plaintiff stroke appellants. First up, pursuant to the said agreement, comma, a draft deed was also prepared, which was produced in the court below, as well as annexed to the present injunction application. You have annexed here. Full stop. Next para. Subsequently, comma, although the pro forma respondent number two honored his part of the contract by selling his 50% share in the entire property, comma, the defendant stroke respondent number one failed to do so. Full stop. On the contrary, comma, the defendant number one gave an offer to sell the property to the pro forma defendant number two at a higher price than the agreed one. Full stop. Next para. It is contended, comma, by placing reliance on the pleadings in the plaint and the injunction application filed in the court below that there is every possibility that the defendant number one defendant stroke respondent number one shall transfer and or create third party interest in respect of the subject property. Schedule A is the entire property.
My lord.
Comma, insofar as his 50% share in Schedule A property is concerned. Full stop. The 50% you have put in as Schedule B? Or
Schedule B, my lord.
you want
B,
injunction regarding Schedule B?
Schedule A, my lord, because B, I am already the owner.
Oh, next para. We find that the learned trial judge refused ad interim injunction without adverting to the relevant materials as discussed above, comma, solely on the ground that without hearing the defendant, the court did not think it necessary to pass any order of injunction, and that there is no urgency, comma, which is contrary to the pleadings of the plaintiff stroke appellants in their injunction application, since at the stage of grant of ad interim injunction, it is the plaint and injunction application pleadings which are to be looked into and proceeded on, prima facie the learned trial judge erred in law in refusing ad interim injunction. Accordingly, we admit the appeal to be heard on the grounds taken in the memorandum of appeal. The respondent number 1 shall remain restrained by an order of injunction from selling, transferring, alienating, and or creating any third-party interest in respect of the suit property till disposal of the present application. যেখানে বললাম respondent number 1 and or his menage till disposal of the injunction application. The appellant shall serve a copy of the injunction application along with the memorandum of appeal on the respondent number 1, indicating that the application shall be listed for hearing on June 23, 2025, when an affidavit of service to that effect shall be filed by the appellants. Affidavit in opposition, if any, shall be filed by the respondent number 1 within June 13, 2025, and reply, if any, thereto shall be filed by June 20, 2025. Service of notice of the application on the pro forma respondent number 2 is dispensed with for the present, since no relief has been claimed against the said respondent.
May I please your lordships?
Talk about that there is a section 5.
Yes, my lord. By an order dated of
Your appearance. Yes. What is the delay?
The delay is around 200 days, my lord.
2400.
Yes, my lord. The petitioner, my lord,
the reason?
Is a domestic help, lord. She would appreciate, my lord. And her husband is an auto driver.
Oh, that, yes.
Yes, my lord. So, my lord, the
what is the suit about?
My lord, it is the suit was for divorce, my lord.
He filed or you filed?
He filed, my lord.
He filed, obtained.
Obtained, my lord, ex parte, against which I preferred an Order 9 Rule 13, my lord. That Order 9 Rule 13 was dismissed, my lord, on contest, my lord. Thereafter, my lord, this appeal has been preferred against the Order 9.
Any remarriage in the meantime?
My instruction is no remarriage. They are continuing living as husband and wife under the same roof, my lord. This is my specific instruction, and this is the only ground, my lord, which, my lord, entitles the petitioner to at least come before your lordships, my lord. Otherwise, my lord,
what is the reason for the delay?
My lord, the reason for the delay is this, my lord, that because the husband continued
you have been living together, so you did not have any inkling of this.
No, my lord, I did not, my lord, I did not thought that, my lord, he is going to enforce this divorce in its in practical terms, my lord, that he is going to execute it by
no, divorce decree was then within your knowledge.
Yes, divorce, because I filed a 913, my lord, and I obtained the certified copy also on time, my lord. 913 order.
Oh, 913 was filed within time.
Within time, my lord. Thereafter, we continued living together, my lord.
So why didn't you challenge that 913 order?
My lord, 913 order was not challenged because of two reasons, my lord. One reason is that, my lord, I met a learned advocate, my lord, who took money from me, my lord. He thereafter, my lord, returned that money, giving an analogy that since a dead man cannot be resurrected. So that's why.
But difficulty, Mr. Chattopadhyay, is that Order 9 Rule 13 and appeal are different remedies, which are simultaneously maintainable. So therefore, Section 14 provision does not apply. Section 14 is bona fide proceeding in a wrong forum. So this is not a parallel forum. These are two different remedies. You took one remedy, took it to its culmination, lost there, and then filed the appeal. You took a chance. Why should you allow this appeal?
May I say this, my lord? My lord, after Order 9 Rule 13 is dismissed, my lord.
You took full chance.
Yes, my lord.
Contested it.
Yes, my lord.
That was you lost there.
Yes, my lord.
Never preferred a challenge. Attained finality.
My lord,
now you cannot reopen that decree.
Appeal is not challenged, my lord.
Order 9 Rule 13?
Order 9 Rule 13 is.
You are challenging the
Order 9 Rule 13, my lord.
So then why the delay?
That is what I'm explaining, my lord. After I obtained the rule, after the dismissal order of 913, my lord, when I was a domestic help, I thought that my remedy in law ends there. So, my lord, I was working in a house.
Where have you stated that?
My lord, kindly sees, my lord. Paragraph 17 onwards, if your lordships kindly have, my lord, of the. That this is where, my lord, it's all started.
What is their educational qualification?
Let's see the domestic help. See.
She has signed.
Signed, my lord.
Domestic help don't look down upon domestic help so
No,
much.
my lord, I'm only trying to socioeconomic condition of the lady is
But
what
they
I'm
have
trying to.
equal status in their villages or wherever they live. When they come here, they have to work in places.
Yes, my lord.
So we think that we are superior.
No, not superior, inferior. I'm just trying to impress upon your lordships the
So you said
socioeconomic.
time domestic help. Yes, we can understand domestic help, but they have equal status. If you go to their village, you will. She may be a queen there.
Maybe, my
Because
lord.
of financial conditions, they come here. So that does not necessarily mean she is illiterate or otherwise, because she has signed also.
She signed. I have said, my lord. I have said that she is
Yes.
semi-literate, my lord, because she could sign, my lord. So, my lord, lordship would kindly consider the predicament of her, and my lord, kindly consider, my lord, that since the husband admittedly, my lord, he is there, my lord, he will apprise your lordships on
Not
behalf
that,
of the
right.
husband, my lord, has continued living with the wife, my lord.
Still you are living.
Still we are living, my lord. Now what has happened? What has occasioned this appeal before your lordship? I mean, indicate, my lord, that he is now using his mother, my lord, to throw me out of the house.
It's her house.
It's a mother's house.
Matrimonial house.
Mother's house.
Acha, when did you come to know about your remedy? What is your explanation to that? Initially, you thought you
Yes,
were
my lord.
remedy.
That explanation, my lord, your lordship says, my lord, I am also to be blamed for that. If your lordship kindly have that, my lord, paragraph 36, my lord. This is where, my lord, I take the blame upon myself, my lord, that I did not know, my lord, that how to go about it, because like your lordship says, my lord, there were two separate remedies. Appeal was there, then 913 was there.
Whether we know you sufficiently enough to believe that you
No,
don't
my
have
lord,
that that you don't have that acumen. You are sufficiently
this is what is fact is.
drilled in civil law, so we have heard you on several occasions.
No, once only, my lord, that.
So we cannot believe you. No, not in this matter. In other matters.
Only one matter.
So this ground we cannot believe that you gave a wrong advice and you were in a dilemma.
I was, my lord. Absolutely, I take it, my lord.
What is the dilemma here?
My lord.
What is the dilemma here?
My lord, because there were two things. One was the decree, and then 913. Then, my lord, how to go? In fact, in the written statement that I have drafted,
Could have preferred challenging is both.
In the written statement that I have drafted, my lord, in the title suit, I have said that I prefer a civil revision, my lord. My lord, if I had known, my lord, at least from 2024, my lord, it's upon me, my lord. Otherwise, I would have preferred, my lord, this is a pro bono matter. I have stated also that, my lord. I am not charging anything, any professional fees, my lord.
Yes, what do you say?
My lord, the main crux, my lord, is this: the husband has filed this mat suit, my lord, on the ground of cruelty. What is the cruelty, my lord? The wife, my lord, purposefully, my lord, trying to destitute this husband, for which they were in a same shelter but in a separate mess under the same matrimonial home. That is my sole ground of cruelty, my lord, before the court below. If your lordship kindly have a look, the conduct of the respondent wife, my lord, in the matrimonial suit, my lord, the respondent wife has get ample opportunity to contest the suit. She has contested the same. After contested, my lord, on the date of evidence, they took a point, my lord, that the evidence was not served upon the lady, my lord, matrimonial wife, my lord. For that,
summons was there. Oh, summons was
some
yes.
of the, my lord, the
Evidence
in chief.
How
My lord,
can
at
it
the
be
time,
served on the?
my lord, it was not
Oh,
served.
the affidavit in chief.
Evidence in chief, my lord, was not served upon the lady. And he was not aware of the
on the merits of the appeal. What about the delay?
My lord, the delay is something, my lord, different. What, my lord, prompted this petitioner from to, my lord, file this instant appeal is the eviction suit, which for reasonable ground, my lord, reasonable requirement, the mother of the husband filed, my lord.
When did you file that eviction?
My lord, 2023, my lord.
My lord, subject to correction 2024, my lord, is the
2023 was the note letter, my lord, I have issued, my lord.
What is the stage of that suit?
My lord, it is in evidence, my lord. In evidence, and today,
so if you filed the suit in 2024,
my lord,
then why do they wait till April 2025? If that was the reason, they would have filed before.
My lord, that can be, they could have filed before, my lord, but what prompted them to, my lord, file within 2023? After receiving this notice, my lord, of eviction, they filed. But not only this, my lord, on 2020.
No, they waited for more than 1 year after receiving the eviction notice. And if the eviction decree was passed,
why, my lord? If they can, my lord, restitute the marital status, my lord, then, my lord,
they'll have a right of living.
They have the right of living over the property, my
the
lord.
opposite applies to you. You are trying to take away the
no, my lord. What happened, my lord? This, my lord, the lady is having a separate land, which she purchased, my lord, and she is also having, my lord, given constructed a room over there, my lord, and also, my lord, engaged a tenant over there, and that too with the money of the husband, my lord. And this is the, my lord, main, my lord, cruelty upon which this husband has preferred this matrimonial suit.
That will decide in
And
the
well, they are not residing together, man. They are not residing together.
same house, different rooms.
Different rooms, my lord. At sometimes, why, my lord, I am saying, my lord, this husband used to reside in rented accommodation. My lord, I have the rent received also, my lord.
You have a daughter,
But I have a daughter. my
class
lord.
10,
No, my lord. She has graduated. She's
now graduated.
Now graduated. She is, my lord, well to
She's living with the mother.
mother, my lord. Obviously, the mother, my lord. But, my lord, these delays.
Throw them out.
My lord, if
Wait
we
for
have
someone.
wished to throw them out, my lord, then we could have initiated these proceedings before after 2028, 2018, my lord. But several cruelty inflicted upon the husband.
No, cruelty will decide. We cannot even decide in the alternate.
My lord, followed, my lord. But, my lord, this delay is not explained, my lord, properly, my lord, because this cannot be a ground, my lord, that after, my lord, getting the marital tie finality, my lord, they have come up before the lordship challenging the order 9 rule 13. But on contest, they have
No, decreed expertise.
but decreed expertise at the time of evidence. my lord.
Suit was decreed expertise.
Suit was
But
decreed
order
expertise
9 rule 13 was their
for a
application.
contest, on contest.
It was their application.
And match suit, my lord, throughout the match suit, my lord, she appeared and contested. But let it be, my lord, but this delay, what my lord and friend is, my lord, placing, that cannot be acceptable, my lord. Because after so long period, my lord, this, my lord, because I should have taken, my lord, instruction, my client might have some engagement otherwise, my lord. Because it's a long delay, long time, my lord. After 2018 to, my lord, 2025, my lord. But it is only to, my lord, get relief from the, my lord, eviction suit. So that if the marital tie, my lord, if the appeal is being admitted, he could, my lord, depose that my marital status is still pending. If your lordship, may I take your lordship to some observation, my lord, of the land trial court's order, my lord. Alternate rule 13, my lord.
No. We cannot look into the merits now. We are only on the section 5 for the time.
If your lordship so desire, my lord, may I just prefer using an opposition to this section 5 application after.
No, we are considering their, even on their, if we are convinced by their application, then only we will direct you. Yes. Till now, nothing has been made out. পুরোটা কন্টেস্ট করেছে, পুরোটা চান্স নেই। তারপর যখন ডিসমিস হয়েছে তারপর টু ফোর্স করছিল 2000 দিন ওয়েট করে, তারপর কোনো লজিক্যাল এক্সপ্লেনেশন নেই। ধরে নিলাম যে ওটাই ওর এন্ড হয়ে গেল, লিগ্যাল রেমেডি আর নেই, ধরে নিল। তারপর হঠাৎ জানলো কি করে যে লিগ্যাল রেমেডি? হাউ ডিড শি সাডেনলি কাম টু নো দ্যাট শি হ্যাড লিগ্যাল রেমেডি?
But that's what I explained, my lord, from
Which
me,
para?
my lord. 36, my lord, if your lordship sees, my lord.
Why did she contact you?
That is there, my lord. Everything is in details, everything is there, my lord. I will just indicate to that part, my lord. My lord, paragraph 32, my lord. That is how she came to know me, my lord.
This is a summons of the eviction suit. When you received that summons, you approached, took legal advice.
She received a summon. She contacted one Dilip Das, my lord, neighbor, her neighbor,
Regarding that eviction suit,
the eviction suit. And then this friend was a friend of Mr. Gautam Sarkar, who works in Panchayat department, my lord. There, my lord, my learned senior went for a hearing, my lord. There, my learned senior was contacted by him, saying that there is a desperate lady. This is her condition. So will you? I was my learned senior was only told to take care of that.
yes, you file an opposition. We may allow this also. So,
Please.
Since you are of that opinion, you are entitled to an affidavit. But we'll restrain you from remarrying in the
grateful.
meantime.
I'm so grateful. I'm so grateful.
That will render the appeal infructuous.
My lord, and this
Affidavit of service filed today be kept on record. Full learned counsel appearing for the respondent husband vehemently opposes the prayer for condonation of delay by pointing out that there is that there is absence of sufficient explanation for the huge delay of 2404 days in preferring the appeal. Next para, learned counsel for the appellant stroke petitioner submits that the petitioner works as domestic help in different households. Next para, in view of her destitute condition, comma, she was dependent only upon legal advice. Full stop. Upon the divorce suit filed by the respondent husband being decreed against her, comma, the appellant, comma, on legal advice, comma, took out an application under Order 9, Rule 13 of the Code of Civil Procedure, which was ultimately dismissed on contest. Full stop. Next para. The present appeal has been preferred against the same. Full stop. Next para. However, comma, in the interregnum, comma, the learned advocate dealing with the miscellaneous case under Order 9 Rule 13 on behalf of the appellant wife had given an impression that the dismissal of the said application was the end of the road insofar as legal remedies available to the appellant wife were concerned. Full stop. Next para. Being a lay person in law, comma, the appellant wife did not take any further step in that regard. Full stop. Subsequently, comma, upon getting the summons of an eviction suit filed by the mother of the respondent husband, comma, who is apparently the owner of the matrimonial home of the appellant, comma, the appellant learned about such eviction suit having been instituted by the mother of the respondent husband against her. Full stop. Since her daughter is a graduate, comma, the significance of the summons was deciphered by the said daughter, comma, upon which the appellant approached approached a neighbor through whom she came in contact with her current learned advocate, and thereafter has preferred the appeal. Full stop. Further time was lost in dilemma, comma, since the learned advocate who was instructed to prefer a challenge against the present impugned order was initially in two minds as to whether a revision or an appeal should be filed. Full stop. Next para. It is further underscored by learned counsel for the appellant that all along, the appellant wife has been living with the respondent husband in the same household. Full stop. Next para. However, comma, learned counsel for the respondent husband denies that they are living as spouses and submits that the appellant and the respondent are living separately in separate mess, comma, although under the same roof. Full stop. Next para. Learned counsel for the respondent at this juncture seeks liberty to file an affidavit in opposition for controverting the allegations made in the application for condonation of delay. Full stop. Hence, we direct the respondent husband to file his affidavit in opposition within 13th June, 1 week after vacation, within June 13, 2025. Full stop. Reply, if any, shall be filed by June 20, 2025. The application shall next be listed on June 23, 2025. Full stop. On oral prayer of learned counsel for the appellant, comma, we restrain the respondent husband from contracting a remarriage till disposal of the application under Section 5 of the Limitation Act.
Well, may I just
So
make an
grateful,
indulgence,
madam.
my lord? This respondent husband is residing separated accommodation, rented accommodation.
যেখানে বললাম in living in separate mess and subsequently in a separate rented accommodation.
Grateful.
So grateful, my lord.
Thanks.
Grateful, lord. Thank you.
Lordship, Lanet's senior advocate Parthopratim Roy is appearing for the respondent.
Parthopratim?
Parthopratim Roy.
Yes. He was there in the morning.
Yes, Your Lordship. He is engaged in courtroom number 6, Your Lordship, praying for short passover, Lordship.
You are submitting, Mr. Dhol?
My lord, we
You have
have
completed.
More or less completed another handicap, my lord. My junior, my lord, is having another copy, my lord. My lord, let it be pass over for a while, my lord. I am
They
also there.
will keep it after the vacation. If both of you are handicapped, why? And keep both of you hanging. An adjournment is sought on behalf of the respondent. Full stop. Let the matter stand adjourned till after the upcoming summer vacation of this court.
My lord,
It will be in the list.
my lord, my lord.
Part matter has to be in the list.
Yes, my lord.
Yes.
Grateful, Lordship.
I'm appearing for the My lord, in this matter also, Mr. Roy is representing the respondent, my lord.
Mr. Gupta has to start. So let us hear Mr. Gupta. He'll come in the middle. In which court is he stuck up?
It's court number 6, my lord.
Who is the judge there?
Probably Justice Kiran my merchant.
It will be over soon. Yes, Mr. Gupta.
I just give him a call, my lord.
Yes. Keep somebody.
Yes, my lord.
Keep somebody here so that yes. Yes, Mr. Gupta. You had started already.
Yes.
Yes. This was an acquisition matter.
An acquisition
Yes.
matter for the purpose of expansion of steel mill
Yes.
of the Steel Authority of India.
You are the requiring body.
This, we sent a proposal to the state government for the purpose of acquisition of the land in 2006. There was a revised proposal was also given, all in 2006.
So Gupta, can you please take the microphone a bit closer?
In 2006, the proposal was given for acquisition.
Yes.
And the state government issued Section 4 notification in 2007. But in the meantime, there was a sale transaction on which the entire case in yes.
You have an order for 27 also.
Yes.
Yes.
5 deeds.
Order for 27.
I have filed our objection to the same, my lord.
You have filed.
We have.
Yes.
You are filing.
Yeah, we have filed. ইয়েতে দেয়া আছে তো স্যারকে দেয়া আছে
Lord, if your lordship kindly takes page 15, I show the proposal.
These are second judge's copy.
Yes.
Why are both stamped?
দুটো করে কেন দুটো অ্যাপ্লিকেশন কেন
No,
ও টু অ্যাপিলস আর দেয়ার মানে টু সেপারেট
two different
অ্যাপিল নাম্বার ইজ দেয়ার
Second judge's copy.
সরি আই গেট তাহলে একটাই বললাম তো তাহলে সুবিধা হবে তাহলে
Sorry, yes. Reply, right. You have given reply to only one.
That will suffice the purpose of only one. Because more,
Same documents as short report.
more or less.
Yes. Yes, Mr. Gupta.
My lord, I first show to your lordship that when we had sent the proposal to the state government, because this will be relevant. In 2006, if your lordship kindly takes page 15 of the paper book, 15 page. This is the estimate note prepared by
Yes.
the state. KLA case number such and such. Received revised proposal from Steel Authority, memo number such and such in connection with the earlier proposal memo dated 7/11/2006 and 27/11/2006. Therefore, from 7/11/2006, people are aware in the locality that land acquisition proceeding is going to be initiated on this. Now, what was the total area of the land? We are actually find also from page 15 itself for acquisition of 14.195. That was the proposal, the revised proposal.
Mr. Gupta, but why do you say everybody was aware? Because that was a proposal sent by you.
Yes, that is a proposal sent by me.
That was not be noticed.
Once the proposal is sent,
Yes.
I shall show certain judgments also, which also I recognize this position.
Yes.
Immediately after the proposal is sent, there is some measurement, etc. At the instance of the land department of the government, people come to know, my lord, that this expansion proposal. Plus, they are all residing nearby. Therefore, they know, my lord, that there is an expansion proposal of the plant. In fact, as a matter of fact, in a judgment, the Supreme Court has also, my lord, accepted this position. Now, so far as this particular appeal is concerned, this is 67.85 decimals.
Yes.
And there are three.
This is FAT 206.
206. There are three different categories of land. And this is not applicable to all the appeals. Three different categories of land, namely Baid, B-A-I-D, Baid, Kanali, and Danga.
Yes.
Baid and Kanali are unarrellable. It cannot be cultivated, uncultivable. And this Danga. This land value was estimated at to be 7,62,191 per acre I am giving these figures on the basis of the award. The LAC, Land Acquisition Collector, had estimated the price of this by the category of land as 7,62,191 per acre. Same rate for Kanali, and for Danga, it was just half of it. This your lordship will find at page 216. Page 216 of the paper book. These
This
prices
is
are
the enhanced award, the enhanced rate.
no, this
Initial
is
award.
Initial. This was followed by a reference under section 18.
The rate was per acre.
Yes, per acre. Then perhaps per acre, the rate description. Your lordship may kindly note that the Land Acquisition Collector's award starts at page 214. Then in the reference before the learned additional district judge, that is at page 34, the value of the land is enhanced. And the enhancement is 21,99,200 per acre. 21,99,200 per acre.
Yes.
In respect of Bayadan Canali, and half of it for Danga land. So instead of 6,74,000, it is 21,99,000.
Right.
Now, we had filed the appeal, the present appeal here, from this judgment after a considerable delay. The delay was not allowed, not condoned. We went up the Honorable Supreme Court. The Supreme Court directed the High Court to condone the delay, and here return made it. And also consider whether because of this delay, any additional amount of compensation should be payable or not. Now, we have filed this application for additional evidence. What are those documents? The Land Acquisition Collector had relied on only one document filed on behalf of the landowner. That was regarding a sale of 2 kathas plot of land. 2 kathas. And the sale transaction was of 2007. What the date? 2007. 13th February 2007. But it was registered on 4th of January 2008. Showing the value at 1,20,000 rupees for these 2 kathas.
What does it translate to in acres, Mr. Gupta?
2 kathas.
Yes, but what does the amount, then what would be the amount for 1 acre taken at that rate?
It is 3.4 decimals. 2 kathas will be 3.4 decimals, 3.4 or 5 decimals.
So you can just ask your junior to calculate. It's very bad in calculation.
Exactly.
Approximate will do.
Exactly.
Approximate will do.
He can possibly computer the calculator.
Yes, calculator there must be convertible something.
0.02.
2
কাঠা মানে হচ্ছে 0.02 একর
0.02
একর
0.02
একর
না ভুল বলছি
No,
no.
That is decimal. You're confusing between decimal and kata.
Decimal kata তুমি তো decimal বলছো
Pardon?
বেশি হবে
60
kata is 1 acre.
No, that's right. 2 kathas equivalent to
So therefore into 30.
3 point something.
2 cutters
I
something.
had calculated, it must be somewhere over here. 3.4 or something like that. There.
So no, is it, I mean,
let him find it out.
very good. Let us proceed in the meantime. Yes. Let us proceed in the meantime with that.
32 কাটা হচ্ছে
Mr. I don't disturb Mr. Gupta.
32 cutters,
You
60 cutters.
calculate your own cutters.
This is not page 1 of the paper. This 2 cutter document. This is exhibit 1. If your lordship kindly mark, makes a note of. This is exhibit 1, a cell deed. This is between the respondent 1 here and this Vishwanath Maji. Presentation, etc. Kindly note this rupees 2,200 etc. paid, received on 13/2/2007. It was presented for registration, executed and presented for registration on 13th of February 2007, and the amount paid was 2,210. Now, execution is admitted on this, then Vishwanath Maji.
He was one of the seller was one of the respondents.
Yes, yes. Respondent 1. Son of Surjanarayan Maji.
He was the vendor.
He was the vendor. You know, the exact document is at page 6.
Yes, yes.
Sell price, translated copy of sell deed, such and such. Sell price. Kindly note the sell deed of 2008. Therefore, he just submitted it for registration. Full payment was not made. Waiting for something, etc. Then sell price 1,20,000 was mentioned.
And according to you,
name of the purchaser.
Yes, according to you, it came to their knowledge in November 2006.
Yes, yes.
So after that, they executed this deed. Might have been taken into consideration the.
No, this is not an authentic transaction. That is what I write to him. Miller plot number measuring 2 kata at the top of your lordship had found. Name of the purchaser, Naresh Chandra Tati. Therefore, this is a private transaction. Naresh Chandra Tati, there is the name of the purchaser. Name of the vendor, Vishwanath Maji. He is the respondent of 1 year. He creates this document. That's my case. So that he can utilize it later on for claiming higher compensation. Now, my lord, when we prepared this paper book, a coordinate bench, my lord, was pleased to direct the bench preserved by Justice Devangshi Vashak that the paper book is to be filed within 2 weeks, and lower court records be called for at once. Lower court records did not come, but we in order to comply with the court order, we had to make the paper book within 2 weeks. It doesn't contain all the papers. Later on, the lower court records came, but no notice of it was given to us because the entire record did not come. Then we took inspection. I'll show to your lordship that the state's stand was that state had obtained information from the registration office regarding various other sale deeds in the nearby areas of the relevant time. And that was one of the documents placed before the land acquisition collector. And the valuation was made by him on such basis. Now, those documents are not available in the lower court records. But we were a party before the reference court. We got ourselves added as a party in the reference court. And we noted, my lord, that the state had, before the LSC, land acquisition collector, relied on certain information state had received from the registration office regarding the sale of other plots of land in nearby areas in same time. We are relying on that.
But there must be something on record.
Nothing is there on record.
Some sale
But
data.
there are observations here. Observations, but nothing nothing could be found in the lower court records.
And one other thing, Mr. Gupta, even if this was a created document, as you say, even then the market value is reflected there. So the value, the consideration could have been created, the sale could have been not authentic, but the market value was ascertained by the registration
Not
office.
the market value concept.
Yes.
As per the Stamp Act and the rules rather.
Yes.
Is that which value is to be accepted? The ADSR they accept, my lord, the valuation mentioned in the deed. If it is more than the circle rate, or then that value is accepted. For whichever is more, if the circle rate is there and the price stated in the deed is less, then the circle value would be. If the price stated is higher than the circle rate, then that higher value will be accepted. You know, that's the
market value was the consideration amount.
Market value that was accepted as market value by the ADSR. You know, I may show the relevant rule in this regard. Whichever is higher, if it is less than
but even then, that is the assessment of market value. That would be the basis of calculating the market value, whatever the stamp.
No, that will be for the purpose of stamp. For the purpose of stamp duty.
But how else could you derive the market value?
You know, the market. If we go by various other documents,
those also would reflect the similar procedure.
No, but the difference will be that as per the rule, the value declared will be accepted as correct if it is matching with the circle, the circle, the unit area.
Matching with or higher than the circle value.
Matching with or higher than. If it matches with this, then it is accepted. If it is lower than that, it will not be accepted. Therefore,
so several deeds is always better than one.
Of course,
to get an average.
Yes,
always better than one.
Not average. Because the courts say that don't proceed by average.
If it's sale consideration, then average. If market value is higher than sale consideration, then market value, the highest.
The highest, the highest one is
highest exemplar.
That is, my lord, exemplary deeds. My lord, the highest is to be taken for the purpose of assessment of the stamp duty.
But that would be the basis of calculating the compensation also. Compensation basis is market value. If the market value is higher than sale consideration.
Yes.
But market value is assessed as you say.
Market value for the purpose of assessment of stamp duty.
Yes.
Is not the same thing as market value of the land. Supreme Court has said so also.
Then how would the market value of the land be calculated?
Market value will be calculated not as I shall show other deeds, which I.
But then also you are relying on deeds to which the same principle applies.
And the deed contains the market value, same thing.
This deed, yes, same thing.
Same thing. But the difference is here, my lord, for 2 katas, 1,20,000, there your lordship will find the value is much less. And that is accepted means that is tallying with or maybe slightly higher than the circle rate. Even and that is accepted. If it
so, we get your point. So that may be closer to the actual rate.
Actual thing.
Because if the consideration is shown as higher, it may be much higher also.
Much higher.
Nobody will go and see.
Yes.
Achha. So you say those are closer to the market value.
Yes, those are closer.
Achha.
My lord, shall I place the rule at this stage?
Yes.
My lord, this is West Bengal Stamp Prevention of Undervaluation of Instruments rules. I am referring to Rule 3. Manner of determination of market value and furnishing of particulars relating to any property. The market value within the meaning of clause 16b of the section 2 in relation to any land or any land with building shall, after taking into consideration the particulars referred to in subrule 2, be determined on the basis of the highest price for which sale of any land or any land with building of similar nature and area and in the same locality or in a comparable locality has been negotiated and settled during the 5 consecutive years immediately preceding the date of execution of an instrument setting forth such market value, or on the basis of any court decision after hearing the state government, or on the basis of information, report, or record that may be available from any court or any officer or authority of the central government or the state government or any local authority or local body, or on the basis of consideration stated in such instruments for such land or land and with building, whichever is greater. If I state an inflated price, that will be accepted. But if I say if I put a lower price, then that will not be accepted. Then what is accepted is the unit yes.
Interfere. Thank you.
Milord, I have, if your lordship at this stage may not kindly permit me to place this application for additional evidence.
So, Mr. Gupta, you are then relying on twofold things. One is the sale data which was produced by the state before the collector. That sale data also reflected the market value, and also these 5 deeds which you are now producing.
Yes, but even the sales data I have not been able to obtain.
Yes, that is difficult.
That also I could not obtain.
These records are very ill maintained. In all the matters, land acquisition matters, at the collector level, we are not getting any documents.
Yes. So we are not parties there.
You could not.
Yes.
But if the record should have been maintained. Anyway, so order 4127 application ta কত নম্বর? Can 3 একটু বার করে দিন? Can 3 Thank you. Yes.
Will kindly take page 4. Paragraph 4, I said that I got myself implemented. Then paragraph 5. Your applicant states that on 9th of March 2012, the judgment was passed by the additional district judge in LA case number sponsor. Therefore, the applicant by your series of letters thereafter, the applicant by your series of letters requested the special land acquisition collector to provide the documents on the basis of which the LA collector.
Give us half a second. এই যে একটা অ্যাপ্লিকেশন আলাদা করে অর্ডার 4127 অ্যাপ্লিকেশন করেছে। পেজ 4 এর শেষে চলে আসুন, প্যারা 5। হ্যাঁ, পেজ 4 প্যারা 5 উনি কন্টিনিউ করছেন, পরের পেজে চলে গেছেন। Yes, by a series of letter request to the LA collector.
You asked for it from the LSC. Then paragraph 6. Your applicant states that thereafter the applicant had filed the instant appeal before the Honorable Court, challenging the said order dated 12. As the instant appeal was filed beyond the time prescribed under the law, section 5. Then 7. The applicant states that on such and such, Honorable Division Bench, presided by Justice Sanjeev Banerjee, please to dismiss the section 5. Then we have the special leave petition. During the pendency of the said special leave petition, the applicant had collected the following deeds of conveyance with his own effort in respect of plots adjacent to the acquired lands in question, and accordingly the applicant had filed an application for permission to file additional documents before the Honorable Supreme Court in connection with the said special leave petition. The applicant respectfully submits that the following documents are absolutely relevant for the purpose of adjudication of the lease between the parties, and these documents would go to prove that the findings of the additional district judge are erroneous and untenable in law.
These were produced before the Supreme Court. Did the Supreme Court direct them to be considered?
No, Supreme Court simply said, send the matter back to the Honorable Court for decision on merits. it didn't utter a word regarding this application. Then we are now the nature of the documents that I have produced. A, sell deed, kindly mark the date 21/4/2006, executed by Turi Bowdy in favor of Mrs. Eastern Coalfields. These are all transactions made between a government company and a private party. All these, all five. Sell deed being transacted dated 21/4/2006, executed by Srimati Turi Bowdy in favor of Eastern Coalfields, and land area is 1.21 acres. Fourth line, A, 1.21 acres, plot number such and such, under Khutian number such and such, total consideration of 11,495. The market value of the said land was 1,33,100. Therefore, this is Eastern Coalfield is purchasing these lands. 1,33,000 is the market value, and it is purchasing at 11,495. My learned friend on the other occasion took the point that because they will provide employment on the land user category, therefore the actual price is 1,33,000. The document shows this 1,33,000, and the consideration money is also shown as 11,490. I shall show this document. I will show one such document. Koto pata? Page 18 of this.
Market value at the top.
Yes, market value, total area 1.21, and then the actually
this is the market value of 1.21 acres.
Yes, 1.21 acres. And the sell value is 11.
It comes to around 1 lakh per acre.
Yes, 11. Well, you also have seen the deed of sell value.
Yes,
11,495. Then
go by the market value.
Market value and total area 1.21 acres. Roughly 1 lakh per acre.
Yes.
And dated 21st April 2006. And who is the next page? Srimati Turi Bowdy. He is the vendor. Next page 3, Eastern Coalfields.
Any employment provision was there in this deed? In this deed, there was any employment provision? Any provision for
is nothing is mentioned here.
Nothing in the deed, but there was a scheme.
The white there was, of course, there is a scheme.
So why shouldn't we? But you say that that will affect the consideration, but the market value would be the true reflection.
Exactly. And this market value, in the objection, my learned friend has stated that this is a market price declared by parties. This is not assessed by the authority. But that is not correct.
No.
Kindly take page 18 itself,
Yes,
right hand side, right hand side top, MV.
MV.
Okay.
Market value equal to okay.
Okay. Then signed D. Mahato, he is the registrar on 21/4/2006. Therefore, this is not the assessed value. Assessed market value. Oh, my learned junior points out that if your lordship takes page 1, they had produced.
That also, they are also similar.
Same man, same register. This I didn't.
Same register may change his mind, like judges.
Well, we had to.
So very well, but that has a
this rule 3.
Yes.
You have to follow the rule.
They have to follow.
Similarly, photocopy B, page 6 of my application. I come back to my application now. I have produced more 5 deeds.
Yes.
B.
So if you have given a synopsis in the paragraphs, then we need not look at each deed. You have given that in your page 6 paragraph.
Yes. The photocopy of sell deed. This is 31/3/2006.
Similar for all.
Similar
for all.
Kindly see the time, the price, and the area of the land.
Yes.
These 3 aspects.
And in the deed produced by them,
yes. And all those deeds are annexed here.
Their deed was dated 13th of February 2007.
Yes, 13th February.
That was, although that was closer to the date of this notification. Notification was of October 2007. But your deed was a few months
But it was
before.
registered, they just submitted it for registration on 13th February 2007, got it registered in 2008, and it's a document of 2008.
2008.
They were waiting after paying some money, my lord.
So you
They
see
did it.
that the registration, the valuation is after the notification. Because the valuation at the time of registration, only the valuation is finally determined.
Before that, no valuation.
So we have to take pre-notification deeds.
Yes.
Pre-notification.
Or if it could be even after that, if it is close to
There are
this,
certain judgments probably, Mr. Gupta, that pre-notification deeds.
pre-notification is
is
more
a standard,
acceptable.
more
Yes,
acceptable.
more acceptable. Yes. In absence of those, my lord, then after.
Yes.
Closely after.
Yes. So if we have pre-notification and only within a year, so then that should be relied on more. That is it.
You know, up to A, B, C, D, E.
Yes, same.
Then, you know, paragraph 9 at page 8 has stated about the Honorable Supreme Court order.
What is the average which comes up from these deeds? That also should have been stated somewhere. But we have to take the highest exemplar.
Yes, not the
Not the average.
average is not.
If it's market value, it's the highest exemplar. That is probably the first one. 1,33,000 and odd. Yes, that is the highest among your deeds. Closest thereafter is 1,26,000. The rest are in thousands.
No, thousands, but then the area of the land is.
Oh, area. Yes. This is the total market value.
Roughly, 1 lakh per acre.
Roughly
1 lakh per acre. Then paragraph 9, my lord, the Honorable Supreme Court was pleased to condone the delay by setting aside the order such and such of this Honorable Court, and that an opportunity should be provided to the applicant to put forth all contentions so that Honorable Court, High Court can take a decision on merits to put forth all contentions. So that your lordships can take a decision on the merits with regard to the judgment and order of the reference court. Then paragraph 10, I have said that we ask the government also to file an appeal.
But this sale data not being available, we cannot look into those. We cannot look into the sale data. Sale data is not there before us.
Sale letter.
Sale data.
Oh, sale data is not.
Sale data is not before. Either you or us.
Unless, my lord, the lower court records are produced before lordship, and we make.
The collector's judgment is there. The collector's order is there.
Yes, the collector's order is there.
He does it reflect any consideration of those?
Yes. It says that the state has produced sale information or sale data.
Sale information, something like.
Sale data, sale information. Details are not there.
If it is not reflected, then we cannot look at that probably. It has to be reflected at least in the assessment.
Yes.
What are the sale data? The document is not there, the data is not. Mr. Gupta will be coming back in 5-6 minutes.
In 15 minutes.
Not more, less than 15.
Could it be 15?
Mr. Gupta will come back and your learned junior can continue. Just
I have some bad habits.
No, please indulge in the bad habit and ask your learned junior if he come back before that. Ask your learned junior to continue. What is the next contention, so that we may continue with the flow. So carry on with whatever is the idea Mr. Gupta will be following. So thematically, you continue. Sale data was not available
Sale data
with
was
you, or even you have checked up the record, it is not available.
not available. But Lordship, I want to first place in the page number 80 of the application, Your Lordship.
18, yes. The first deed.
First application. Lordship, this is the letter issued from the additional district
Page number
magistrate.
18 of?
80 of the application, Your Lordship. Can application. 80. Annexure B, Your Lordship.
Yes.
Lordship, the letter issued from the additional district magistrate LA Bardhaman to the Assistant Secretary Government of West Bengal Land and Land Defense Department LA Law Branch Nabanno. In this letter, you'd like to submit that I'm read the content of the letter. In connection with the subject above, I would like to submit that an order was passed by learned additional district judge, third court ward 1 in LA reference case number such and such, arising out LA case number such and such. In view of said judgment and decree, learned GP ward 1 has opined on 30th July 2013 in favor of seeking opinion of the RB for preferring appeal against the judgment and order. The RB being the ISCO cell Vanpur Bardwan has opined through their memo number such and such in favor of the preferring appeal. In this letter, kindly see Lordship the enclosure, eventually Lordship, that the pro forma report along with the grounds of the appeal. This eventually pro forma report, on the basis of the pro forma report, Lordship kindly see that next page number 81, eventually Lordship, and this is the last part. What is the pro forma report? The collector has assessed the market value of the land on the basis of sale data collected from registry office arising to the period 2006 and 7. Now, Lordship, kindly in the paper book, page number 45, eventually Lordship. 46A is the type copy, eventually Lordship. 45A of the paper book. These eventually sale data must be submitted before the LA collector at the assessment of the compensation, eventually Lordship.
On available deeds and records.
Available deeds and records, eventually Lordship. So
but we
these
cannot go on inference. That is a difficulty. Difficulty is we have to then proceed on inference.
Yes, Lordship.
Because in fact, the reason for providing reasons in judgment is that the appellate court, where appeals are provided, is that the appellate court can look into the reasons given. So that is the premise of this requirement for giving reasons. In certain cases, in certain departmental things, reasons are not even required to be given. Or even in arbitration cases, parties can agree not to be given. Therefore, but records are not before us just because the collector said that is not sacrosanct. That cannot be sacrosanct.
But the government has to file this eventual report, because the LA collector is the report.
Government is true to its normal, spirit.
Yes.
In government appeals, we are not getting data. Learned government council are on the verge of crying. Day after day, they are trying to convince the records are not available. Collectors' records are not available. Government appeals are being dismissed unnecessarily.
Yes.
So forget about your case. Government's own appeals, they can't provide data.
Now, Lordship, now I am.
Therefore, we have to proceed on whatever is available before us. Your 1 lakh average and Mr. Rai's that more than that 1,13,000.
Now, kindly, Eventual Lordship, I am pressing Eventual Lordship page number 17. That is the estimate note, Eventual Lordship. In the estimate note, it is specifically stated, Eventual, that
17 of
17 of the paper book, Eventual Lordship.
Yes.
Lordship, the third paragraph. There are no sufficient sales of Mouja Boradigari, jail number 10. That is the acquired eventual land in the Mouja Boradigari, PS District Ward 1 Mouja, Boradigari, Swarnomara and Lakshasudha are just adjacent to each other. So therefore, there is no sufficient sales. When sale deeds has not been recorded in respect of Mouja Boradigari, Lordship.
Regarding Shanmara and Lakrasota,
Yes, Lordship. Just adjacent to each other and attached to village and situated on the same road. Advantages, disadvantages, and potentiality are more or less same. The subject is surrounded by the area which already owned by ISCO covered under the area of Mouja Swarnomara and Lakrashota and other adjoining Moujas. The rates of Mouja Swarnomara in connection with LA case number such and such were prepared on the basis of approved rate of LR department Mouja
Estimate note
Lakrashota.
is a part of the collector's records.
Collector's records, Your Lordship.
Yes, please continue.
In connection with the LA case number such and such, which approved by the collector Bard 1 on 30th November 2007. Now the second paragraph, Lordship. The matter is discussed with the collector Bard 1 in the presence of ADM LA Bard 1 on 20th December 2007, and considering all aspects, it is decided that the rate of Mouja Boradigari will be considered as per approved rate of Mouja Swarnomara in connection with the LA case number such and such.
No, this is the enhanced award.
No, this is the
Original.
award of the collector, original award. Hence, the rate of Bait, Kanali, and Danga class of land are adopted from LA case number such and such. Now the rate comes of rupees that is recorded in the LA collector order in
But
the award.
you did not challenge this.
I did not challenge. This award had been challenged by the
There,
service.
obviously.
Yes,
But if
Lordship.
you did not challenge it, then I mean, now you are producing deeds which say 1 lakh per acre.
1 lakh per acre.
We'll ask
Because-
Mr. Gupta about that. Mr. Gupta, the collector proceeded on the premise that this 7,62,000 and odd, as you said.
Yes.
You did not challenge that. But now can you produce deeds to say that it's 1 lakh, not 7 lakh?
I can produce deeds. It's for the court to accept, my lord, the valuation. Court to fix the
Then
valuation.
virtually the original collector's award would be under scrutiny then. Can we do that in this appeal?
No, but your lordship can, my lord, your lordship can always say
That has merged in the enhanced award and all. We can say that.
exactly.
Merged in the enhanced award and we are taking up an appeal against the enhanced.
Yes.
But then this will also
But
go down below that.
possibly your lordships may not accept 1 lakh, but the collectors.
At least the collectors.
Yes.
Enhancement cannot be there.
Enhancement.
At least that much.
Yes. As your lordship said that possibly I cannot say that it should be on the basis of 1 lakh. That may not be accepted. No, my lord.
We are discussing that this is the beauty of your argument. So
My lord,
we need not be bothered about other aspects of fairness. Yes.
My lord, perhaps at this stage I should mention the provision of the law under which, my lord,
Yes.
the Civil Procedure Code, Order 41, Rule 27.
Rule 27, yes. You come under court requires
I
B.
really, yes, I
B,
really come under
B, B.
I cannot go by A or A.
Double A is not applicable. A is not there at all. So by B.
By
Well,
B. Yes. My lord, I beg to cite a few judgments on this.
Please. So, Mr. Gupta, your case up to now is twofold. One is that their deed was created and not authentic for the reasons you have given. And you are producing 5 sale deeds which show that it's much lower.
Yes, much lower.
Much lower.
Up to that, my lord, I have. Now, how far this additional evidence will be acceptable or not?
Yes.
That is on that aspect, my lord. I refer to this Order 41 itself.
Absolutely.
And now the judgments on this.
Yes.
Now, for the first judgment, my lord.
So your judgments will be on Order 41 Rule 27.
Yes. I cite 2 judgments on this.
Yes.
Your first is 2002, Volume 6, Judgment today. I have read this judgment in 2002. I didn't find out from the Supreme Court cases. It's not reported in 2002. It's reported subsequently. I gathered last night that it is reported in 2015. This 2002 judgment published in
Found out
Judgment
later.
Today. Judgment Today in 2002. But this decision is printed in Supreme Court cases in 2015.
You can give the Supreme Court cases citation.
Yes.
That would be easier for us to.
Lordship.
But you are handing over in any event copies. Whichever citation, either of the two, just give.
কোনটা দিচ্ছ?
You give both citations, Mr.
Yes,
Gupta.
yes.
We'll
Lord, this
note
is
down.
2002 volume 6.
Yes.
JT
Yes.
16 paragraphs 4 and 7, and the corresponding is 2015 1 SCC 677 paragraphs 2, 5 and 6.
Oh, one লেখা আছে। Thank you. ঠিক আছে। This is Supreme today.
This
is a third.
No, Supreme today দিচ্ছ নাকি?
Yes. This is the third
The Supreme Court cases 2005 15 1.
And the Supreme Court cases have also been given. তাহলে এটা ফেরত দিন। Same judgment. এটা ফেরত দিন।
না না তুমি অন্য দিয়েছো 15 1 SCC তে দাও।
ওই একই জাজমেন্ট। 15 না এটা কি আছে? এটা What is the first page of Justice Kumar's copy? আচ্ছা এই জাজমেন্টটা ওটা না
কি করেছে উল্টো পাল্টা দিয়েছো নাকি?
না না ওটা দিয়ে দিন চট করে টু লিখে দিয়ে দিন টু না লিখলে তো দেবেন এটা ফেরত দিয়ে দিন Yes, 256. Short pointer is it?
Paragraph 2, your lordship kindly see.
Yes.
Supreme Court cases, the short point that arises for consideration in this appeal is whether the Board of Revenue was justified.
Gupta, this is settled. Invocation of clause B does not depend upon the vigilance or negligence of the parties. If it is required by the court, definitely we can. But that is the discretion of the court, obviously to be judicially exercised. Yes.
Of course, yes. This is the only point here.
In one of the cases, we have dealt with a situation where AA was sought to be overridden by B, by citing B. But it was a clear case of AA. We held that this here B, we don't require it otherwise. Then AA comes into play and this.
Yes.
But here probably you are on a better footing because one deed only produced by them, sale data not available, and you are producing 5 deeds which are more or less contemporaneous.
Yes.
So B scenario might be attracted here.
Yes.
But we have noted 5. Actually, paragraph number 5 at the end, the invocation of clause B does not depend upon the vigilance or negligence.
Exactly.
That is what you are coming to.
Exactly.
Yes.
Now, the other judgment is 2005, volume 3, Calcutta Law Times. (196). Paragraph 15, 1-5.
Yes.
My lord, kindly come to the middle of this paragraph.
Yes.
We cannot understand the argument on the part of the learned senior counsel. Have your lordships kindly got it, my lord?
Yes, we cannot understand.
We cannot understand the argument on the part of the learned senior counsel that we could not allow the documents to be filed at the appellate stage.
Whatever. Motion.
Junior আছে তো?
You're having a loose motion, Mr. Rai. So many motions together.
We cannot understand the argument on the part of the learned senior counsel that we could not allow the documents to be filed at the appellate stage. There was nothing wrong if the documents which are not available with the party are read by the appellate court on the principle of Order 41, Rule 27. Here, my lord, application under Order 47, Rule 1 was also not made.
Yes.
Still then, not the court considered it.
Actually, B scenario application is not needed. Even.
Exactly. It's entire discretion of the court. If justice requires it, your lordships can always look.
It is doubtful even in A whether it's needed. In double A, yes. But in A, where the document was before the trial court not marked as an exhibit, should have been marked, then also we can look into the records and do it.
Exactly, exactly. Now, my lord, kindly omit a few lines. We accept the explanation. We accept the explanation offered by the learned counsel for the appellant that the documents were not available for being filed. With that view, just not this reason, that those are not available to be filed. With that view, we have decided to look into the documents filed by the appellant. In our opinion, even the documents were not required because the very documents filed by the petitioner were enough to come to the court. That's a different aspect. Since it was not available, the court feels that if it is necessary for the ends of justice, then we shall look into it.
Good. But this then comes within AA also. Here, because court says that we accept the explanation offered that documents were not available for being filed, which comes under AA actually.
But here also, my lord, these were not available with us.
But you could have obtained if you.
I could have, but my lord, I said, my lord, that since we were really, my lord, surprised to find that the state did not produce anything. My lord, in spite
you could have
of
produced during the enhancement in the enhancement proceeding.
Yes, in the enhancement.
You came there as a party for the first time.
I came there, yes, for the first time.
There you could have
and
produced.
I could have, but my lord, I find from the records that the state had produced before the land collector certain documents, facts, information, etc., from the collected from the registration office.
Yes.
Therefore, we relied on that.
Very well.
Now, my lord,
and you have got a much stronger case on 4127B also.
B, exactly.
than the other cases.
Yes. On B, my lord, I have it. Now, my lord, regarding the merits, determination itself of this. My lord, 1995, Volume 1, Supreme Court cases. Seven 1995, Volume 1, Supreme Court cases 717. Yes. Paragraph Miller 9. I place paragraph 9 first. Miller, there 9 after about line 10. After 10 lines, it will be obvious.
Yes.
It would be obvious that the proposal for acquisition would take long time for its taking final shape, culminating in the issuance and publication of notification under Section 4.1. The proposed acquisition would be invariably within the knowledge of the owners of the land. Now, why this? Because, my lord, the persons residing nearby in respect of a plant, steel plant, my lord, they are generally, my lord, contract laborers or something, or they are some of them.
Yes.
They know, my lord, in the exact situation. It is apparent from the dates of sale that they were not bona fide sales between a willing vendor to a willing vendee, and price shown in the sale deeds were inflated to boost up the market condition for determination of compensation. Exhibit A3, the award and decree of the Civil Court of 1977 acquisition, wherein compensation at least 50 was fixed, is also based on the got up sales. These factors were not critically examined either by the reference court or the High Court. So these sales are also do not assist the claimants. Equally, Exhibit A12 in OP number 56 is also based on the basic value register, and its foundation is knocked off at its bottom by the decision of this court. For the said reason, the determination of compensation is vitiated by application of wrong principles of law. Then we will kindly take paragraph 11, the bottom of paragraph 11. The last, in Gulzara Singh case, the last about 6 lines from the bottom, paragraph 11. In Gulzara Singh case, it was found that the sale deed, Exhibit A9, was a genuine sale deed between a willing vendor and a willing vendee, and it furnished the basis for determination of the market value. It was also found that the land was situated in the developing area Accordingly, this court took those factors into consideration and had fixed the market value on the basis of potential value of the existing conditions. Then paragraph 12, the last sentence. Though the acquisition was for providing house sites to the poor, there have been no building activities in the neighborhood. There is no rise in the market condition, and since the lands are admittedly agricultural lands, as on that date, the fixation of the market value as agriculturally is just and fair, instead of remanding the case as contended by Sri Tata Rao for the further evidence. Here, no document was found to be bona fide. Then what the court did? Paragraph 13. In the first case, the notification was of the year 1983, and in the second case, it was 95. Taking these factors into consideration, we find that the market value of the lands covered in the first case would be determined at to be 65,000 per acre, and for the lands in the second case, market value would be determined at 80,000 per acre. The claimants are entitled to additional interest, solicium, etc.
What was the basis of this?
I don't know.
140.
Exactly. But this part is 140, paragraph 30.
But the rest is?
Yes.
And here we have documents. You are producing documents.
Yes, I am producing. Then the next is 2001, volume 6. Volume 6, Supreme Court cases 254. Oh, yes. Paragraph 5, 6, and 7. Paragraph 5, I read out.
Yeah.
Counsel for the state was right when he submitted that the High Court erred in rejecting exhibits R2 and R3 as inadmissible only on the ground that the parties to the documents had not been examined by the state. It is not either the vendor or the vendor. That's what the previous judgment was, that either the vendor or the vendor has to be examined, or in their absence, at least the witness. That was considered by the legislature, and section 51A was added in the Land Acquisition Act. And 51A says that such examination is not necessary. And read with section 57 of the Registration Act, which says certified copies are admissible in it. Now, it is not the law that a certified copy of registered agreement for sale is inadmissible in evidence unless the parties to the documents are examined to prove it. That would be contrary to what section 77 read with section 74(2) of and 76 of the Evidence Act 1872, and more specifically section 51A of the Act provide. As far as the provisions of the Evidence Act are concerned, a certified copy of the registered sale deed is admissible in evidence and does not need to be proved by calling a witness. Then 6. Section 51A of the Act is to the same effect. In Land Acquisition Officer v. such and such, it was held that by virtue of section 51A, a certified copy of a document registered under Registration Act 1908, including a copy under section 57 of the Act, that is certified copy, may be accepted as evidence of the transaction recorded in such documents. It is open to the court to accept the certified copy as reliable evidence and without examining parties to the documents. This does not, however, preclude the court from rejecting the transaction itself as being mala fide or sham, provided such a challenge is laid before the court. Now, in Baldev Singh, the sale deeds produced by the claimants were challenged as collusive. It was alleged that the sale transactions had been entered into only for the purpose of inflating the market value in anticipation of acquisition proceedings. It was in this context that the learned judges of this court held there is no proof of passing of the consideration thereunder or the circumstances in which the documents came to be executed. Under these circumstances, all the documents are inadmissible. Passing of the consideration.
So in their case, it should have been proved, brother.
Yes.
Not in your deeds.
Yes. Therefore, they have no evidence about the passing of the consideration. And kindly see, my lord, in order to be within the Registration Act provisions, they had presented the document within 4 months of execution and remained silent, didn't take further steps. And only in 2008, my lord, the registration took place.
What prompted them to wait till 2008?
To
What
wait
would
till
be the-
2008, no, as to whether the
Whether
acquisition actually takes place or
takes
not.
place or not?
If it doesn't take place or not, they will not proceed further with the document. And the last judgment, uh, 2001 volume 3 Supreme Court cases 530. এই 2001-3,
Yes.
2001-3 Supreme Court cases 530. দেখেছি আপনি paragraph 13, 1-3. If the position regarding admissibility of the contents of a document, which is a certified copy falling within the purview of section 57(5) of the Registration Act, was as adumbrated above, even before the introduction of section 51A of the Land Acquisition Act, could there be any legitimate object in incorporating the said new provision through Act 68 of 1894? It must be remembered that the state has the burden to prove the market value of the lands acquired by it, for which the state may have to depend upon prices of land similarly situated which are transacted or sold in the recent past, particularly those lands situated in the neighboring areas. Therefore, my lord, the burden is really on the state. The state is making the acquisition. State has to prove the market value. AIR 89. AIR 1989 Supreme Court 2051. হ্যাঁ হয়তো প্যারাগ্রাফ মিলিয়ে দেখা উচিত প্যারাগ্রাফ মেলাবো কি করতে হবে 2051 প্যারাগ্রাফ 4 দাও দর্শককে দাও জাজমেন্ট দেখি একবার প্যারাগ্রাফ মিলবে do not feel আর তো শেষ হচ্ছে কি করে না ঠিক আছে প্যারাগ্রাফ 4 মিলর we do not feel called upon to enter into a detailed scrutiny of the evidence laid by the parties before the learned civil judge. The main instance relied upon by the claimants was by way of an agreement to sell dated 21st January 1957 and a sale deed dated such and such in respect of the sale of so many square yards of the land out of survey number such and such, which adjoining the land with which we are concerned, which forms part of such and such. You know, kindly come to the the last about 10-12 lines. The market value of a piece of property. Have you lordship kindly got that part? The market value, a line about 12 from the bottom. The market value.
At page 254. Yes, got it. Yes.
The market value of a piece of property for purpose of section 23 of the Land Acquisition Act is stated to be the price at which the property changes hands from a willing seller to a willing buyer, but not too anxious a buyer, dealing at arm's length. Prices fixed for similar lands with similar advantages and potentialities under bona fide transactions of sale at or about the time of the preliminary notification are the usual and indeed the best evidence of market value. This is what I produce.
Admitted position.
Not too anxious a buyer. Bona fide.
Bona fide. Bona fide transaction.
The armchair rule, willing purchaser, willing buyer, is a
Not
very,
too
very
anxious a buyer, bona fide transactions.
yes. Now, my lord, there is another judgment. The court will take itself in the position of an armchair policy that what a willing purchaser will sell at what price to a willing buyer. That's the consideration. That is, my lord, 1996-10 Supreme Court cases 607, paragraph 3. Paragraph 3 at page 609. At page 609,
Yeah.
8th line from the top of this paragraph, it is settled law that
Yes.
it is settled law that court in determining the compensation should sit in the armchair of a willing vendee and determine whether, in the given facts and circumstances, he would be willing, depending upon the prevailing market conditions, to offer the rates which the court proposes to determine as a prudent purchaser. This is the basis. হলো করতে পারলে?
Got an order there?
Eh?
Got an order there?
Ejected.
Rejected. Then statistics goes in your favor in this matter.
Oh.
It's on a similar proposition, Mr. Gupta, you need not multiply too many judges.
Yes. Well, kindly accept this 1995 one to দেখেছি তো
95 1 has been shown.
717.
You started with that.
Paragraph 10 to 13, na? 9 to 13.
No, paragraph 7 of that one, kindly take this 95 one once more. Paragraph 7. What is the method, reasonable method to determine? Paragraph 7.
Yes.
Paragraph 7 at page 721.
Yes. Paragraph 7.
The reasonable method to determine the market value of the acquired land is on the evidence of transactions of bona fide sales of acquired land, but not on evidence of sales of such land got up, having had knowledge of the proposed acquisition. The former will furnish reasonable basis to determine the compensation. In its absence, bona fide sales, but not manipulated sales of the lands in the neighborhood possessed of same or similar quality and having the same or similar advantage would give an unerring assurance to the court to determine just and proper compensation. Such sales must not only be proved, but also be bona fide transactions, etc.
This goes against you. The vendor and vendee then has to be to show bona fide.
No, this is not this is subsequently I have shown to your lordship, but this is not the correct position in law. That change in law has not been noted. The vendor, vendee, or the witness, etc. This aspect, my lord, in 2001 judgment I have shown, my lord, this is the law has changed. The court did not take note of this section 51A brought in the act in 84.
So you need not place this paragraph.
I don't know. Therefore, my lord, in conclusion, my lord, I'll say
yes,
that the documents that I intend to produce are a sale between a private party and a government company. Therefore, this is more reliable and not private transactions. Second point is all the five deeds are not private transactions with government undertaking. Secondly, the market value is shown in the document. All these five documents have been accepted by the registering authority.
Yes. But if it's a registered sale deed, Mr. Gupta, wherever its market value is shown, that cannot be registered unless that is the accepted one. They compel you to put in the market value.
Yes, the market value.
Unless they accept it, that won't go through. The registration won't.
The registration will not take effect.
Yes.
Therefore, the acceptance of the market value is dependent on Rule 3. Where I mention it, if I mention your 1 crore price, they will accept it because that will give them more duty, stamp duty.
Right.
That will be acceptable. Yes. But a lower value, if it is lower, if the price is lowered by the parties, that will not be accepted. Previously, the high price properties were used to be sold by stating very low price when these rules were not there. That position has been changed totally. And the third aspect is that the only sale deed that has been relied upon of 2 khatas, it is not even comparable because it's a small plot of land. Secondly, it's a private transaction. And no evidence regarding passing of consideration here. A private transaction.
So the Gupta will record appearances only up to your last submission.
Now, a point was raised that before the additional district judge and the reference court, my client Millard gave an assurance that the amount determined will be deposited within a month.
Oh,
that point was taken initially.
What about that?
Now, yes, Millard, that was on the basis of a government letter which said that you deposit, kindly take this, kindly note the stand of the state. The state Millard does not produce any document, anything before the reference court. And on the contrary, Millard, after the award is passed by the reference court, we by letter asked the state to file an appeal. The state didn't file an appeal. On the contrary, the state issued a letter to us saying that you pay this money, you deposit this money, otherwise our bungalow the DM bungalow will get attached.
Is that recorded in the reference court's award? Your assurance?
Yes.
Let us see that portion, whether it tantamounts to a concession.
কত পাতা বলো তো? তুমি আমাকে হেল্প করো না, বলো না।
Opposition page 24.
কোথা opposition?
No, in the paper book it's not there. It must be there in the paper book. Let us follow the paper book.
Not there in the paper.
Not there in the paper book.
The impugned judgment is not there in the paper book.
Not impugned, subsequently. The money execution case, yes, sir. Case 24.
Yes, sir. Page 24 of their affidavit in opposition.
To the order of Order 27.
আর এটার আগে জমা দাও। The page 25 first of the affidavit in opposition. In can 3. Page 25. The learned GP pointed out to this court that there is an appeal pending before the High Court. And stay is yet to be heard. In this case, the date of award was 12 and this is 17. Government delays are known to all, particularly in India, but the government should have been, others should not be first, which is lacking in the government. The learned advocate for the decree holder submitted his client is Vishwanath Maji.
The government should have been fast to teach all the others.
No.
But others should also be fast, which is lacking in the government.
Now, even if there is no mistake in nomenclature, government cannot be allowed to be given time, even after 5 years, and say appeal is pending before High Court. And if that is allowed to be stayed by any court in India, it will only pave the way towards injustice to the claimant whose land has been acquired. Justice should flow from top to the bottom because, etc. There is no question of accepting the stand of the government in this connection, since there is no stay from the High Court, even after 5 years from the passing of the word. Attachment or self-proclamation.
But in case of judiciary, justice flows from bottom to top. Someone like Mr. Bose must have been there. The justice flows from top to bottom because water never flows from the ground to the top, and hopefully the same physics will remain and all these things. Someone who specializes in language and more than law. Law also, but
attachment or self-proclamation is the only way to give relief to the decree holder, in spite of knowing that the appeal is pending, and to perform the duty of a court to enforce its own decree or award. The requiring wording being the part of the union government and the state government as well as, is given 30 days time to honor the award. Otherwise, this court will have no other way but to.
This is not your concession.
No, then page 24. Page 24, the previous page. Because one letter is not here. That is a letter from the government asking us that you deposit it within this time. Otherwise, the government will face problem.
But you need for 1 month's time to honor the award.
To deposit it.
At that point of time, also appeal was pending.
Appeal was pending, yes. Appeal was pending with section 5, perhaps. The Supreme Court order says High Court will decide it on merit. That's the first thing. Secondly, this is this undertaking is on the basis of a threat.
Under threat from whom? The government?
Under the previous order of the otherwise self-proclamation will be issued.
That was the previous order.
Is that page 25?
Oh yes, it's chronologically, I mean, reverse.
Yes. Otherwise, this court will have no other way but to allow self-proclamation to proceed. Self-proclamation of the DM's one.
We thought that was a subsequent order. That's why
no,
that page 25 is previous to page 20.
Yes, previous. '25 is dated 22nd May.
Yes, it's previous.
Yes, please.
Reverse chronology.
Yes. We have got a letter, that again, that's not part of the record.
That is not a threat, but self-proclamation is definitely a threat.
Yes.
Plus the Supreme Court direction. Merits.
Regarding Supreme Court direction, Mr. Kollol Basu reminds me of that. Relevant to this aspect.
After it has been argued by you at least 10 times when he was not there. That is why, Mr. Gupta, we are saying, please let us do it. Up to the last judgment you have cited, the appearance will be recorded.
Exactly.
Yes.
Okay.
Today, definitely, yes. We'll have something for the vacation. Why no? Justice flows from top to bottom. That physics will remain.
That is Mr. Boss.
No. Top is Mr. Gupta. So you are bottom compared to him. So let it flow.
Today,
No, Mr. No question. Part matter We have made it hard in. We have hard in part today. Mr. Gupta is finished. Argue your case, Mr. Rai. So what? We have done some motions. We have given you permission.
Yes.
We are permitting Mr. Bose also to leave. So no difficulty. Yes, Mr. Rai, what is your answer?
Yes.
It appears to be a non-authentic document, inflated price.
According to inflated price,
Appears to be so also. The timing and the registration,
Timing.
you waited for this.
now if your lordship and kindly considers this time, the initial notification. I return to page 20 of the paper.
You're reading the matter or?
I need some time because ultimately, because the judgment which I've cited, I have to counter all those judgments. I'll come back only one day. I'll complete. I will not take much. Yes, well, because the judgment which I've cited, I have to counter all those judgments. I have all my judgments also. That is why I'll come back. I'll argue this matter on that point. Anyway, otherwise, I'll not see.
Mr. Rai. Heard learned senior counsel appearing for the appellant puts up on the prayer of learned counsel for the respondent, comma, in order to enable the respondent to give their reply, comma, let the matter stand adjourned till after the upcoming summer vacation. It will appear in the monthly list under the same heading.
Let it be marked as hard.
প্রথম লাইনে করে দাও হার্ড ইন পার্ট না না তার প্রথমে দিও না হার্ড সিনিয়র কাউন্সিল বলেছি তো লাস্টে যেখানে বললাম বি আর্জেন্ট টিল আফটার দ্য ভ্যাকেশন অ্যান্ড বি মার্কড অ্যাজ পার্ট হার্ড
To the APD opposition.
আরেকটা লাইন অ্যাড করে দাও affidavits in opposition and reply filed in connection with the application under order for rule 27 of the code of civil procedure bracket can 3 of 2025 comma filed today comma be kept on record.
আরেকটা কি 2006 পর আরেকটা কি 206 পর আরেকটা কি দুটো বলে দিস
দুটো
you have filed reply to both
আমি মাঝে আবার কি
ঈশ্বর ছেড়েছে দুটো ফিক্স করি
yes what happened
I fixed mentioned this at 2 p.m. those matters has been fixed
where
well those before
here
not here well that is why
motion today 1 day before the vacation 2 days before the obviously you have a point there thank you none appears for the parties adjourn for the day.
My lord, I am led in this matter by learned senior Mrs. Manju Agarwal, advocate. She is standing on legs. Let the matter be passed over.
Not today then. On the prayer of the appellant, the matter is adjourned for the day. Next.
Deeply obliged.
Please give your name, ma'am. Your name. None appears for the parties. Adjourned for the day. Same.
Lordship, on behalf of the appellants, praying for a short passover. My senior will come and argue the matter.
Short passover. Very well, passover.
Item number 25.
None appears for the parties. Adjourned for the day.
Item number 26.
Appear for the respondent, not
Dekhi order sheet. Was it called on some earlier occasion or for the first?
Twice, my lord. Twice they were
Let us see the record.
And one day everybody missed, my lord. Certainly collapsed, and that day extraordinary circumstance. Twice they called. Not part
Mr. Chakraborty, before the vacation, we are not dismissing, so let us adjourn.
dismissing, Lord. May I complete my submission? Let it be marked as
How
part.
can it be?
Very short matter.
No.
Very short
No,
matter.
not before the appellant.
I have prepared a notes and argument. I shall submit and I will complete.
Yes,
my
but unless
Lord,
somebody comes,
it is not a. May I say?
we cannot hear the
Let me
respondent.
predicament, my lord. Part of the executive duty is partly executed.
We'll record an order that none appears for the appellant, but on the next occasion, remind us after the vacation. If they don't come, then we'll take up.
Last time, last chance. my lord.
Last chance, very well. No, but on the last occasion, on the prayer of parties, it was
No,
done.
on that day, my lord.
Oh, because Justice, I was
they-
sitting with Justice Samanto, not a
Yes,
regular.
yes, not now. On that day, my lord, they prayed for accommodation, and the next available day, I have some difficulty. That's why my lord recorded in this fashion, my lord.
None
Actually,
appears
they-
for the appellant, although the respondents are represented through counsel. Full stop. Learned counsel for the respondents insists that the matter is short and may be taken up. Full stop. However, as a last chance to the appellant to argue the matter, the same is adjourned for the day. Last chance.
Last chance, I need it.
None appears, adjourned for the day.
Number 28.
Item number 28, I pay for short password.
Why short password?
My senior is the
What is the matter about?
matrimonial.
Who is your senior?
Papu Odhikari.
Then we are adjourning it for the day. An adjournment is sought by the appellant. Let the matter stand adjourned for the day. Give your name, please.
29.
29, none appears, adjourned for the day.
Item number 30.
Same. Same.
Item number 31.
My lord, 31, I'm appearing for the respondents number 1 to 6, my lord.
35.
31, my lord.
31. None appears. Please give your name in the inbox.
My lord, may I make a submission? My lord, the appellants are enjoying an interim order, but my lord, they are not appearing, my lord. Last occasion also, they did not appear.
देखिए एक बार record order sheet.
My lord, the last order is dated 23rd April 2025.
We'll just check up the file.
Yes, ma'am.
Order sheet লাগবে just. We find when the matter is called on for hearing, comma, the respondent numbers 1 to 6 are represented, comma, although none appears for the appellant. Full stop. Learned counsel for the respondent numbers 1 to 6 rightly points out that we had recorded in our order dated April 23, 2025 that on the said date also none had appeared for the appellant. Full stop. Next para. As a last chance to the appellant to argue their matter, the same is adjourned for the day. Full stop. It is made clear that in the event the appellant remains absent or seeks an adjournment on the next occasion when the matter is called on for hearing, comma, appropriate orders may be passed in that regard.
My lord, they're enjoying an interim order as well, my lord.
Let them enjoy the interim order. You enjoy the vacation, come back after.
Grateful, ma'am.
Next.
28 will have for the respondent, which is action.
Next matter. Yes. None appears for the parties, adjourn for the day. যেগুলো নান আইপিএস করছি পরে সে নাম ঢুকিয়ে দিলে ঢুকিয়ে দিও না
Item 20, I am for the respondent number 1, my lord.
You are item 31.
21.
21 you are late by a day. Call on the next matter.
Item number 33.
33, I am for the appellant, my lord.
Yes, you can
Matrimonial
start
appeal,
the-
my lord.
What is the matter about?
Yes, my lord.
Could
Decree
you
of
start the hearing or keep it after the vacation?
No.
Recording your presence.
matrimonial appeal, my lord. Like, well, I can start, my lord.
You are the husband or the wife?
If my lord says after recess, I can no, I
Can
can
you,
start
who is appearing for the other side? Mr.
other
Chakravarti?
side কি আছে সুকান্ত ঘোষ
Can you give a notice to Mr. Ghosh?
I mean ask him
We'll just pass it over. If both of you come, we'll take a pass over it.
it is also urgent, my lord.
Pass over. Matrimonial all matters. Yes. Pass over.
For a long time.
None appears for the parties at the time of call, adjourn for the day.
Item number 36.
Same. Same.
Item number 38.
Same. পাঠ আউট করলে উপরে চলে যাবে।
Item number 39.
Same order.
Item number 40.
Appellant. Mr. Mahato, who is for the other side? Paper book.
It was directed that without paper book, the appeal will be heard because my lord, the suit for defamation has been dismissed, my lord, on maintainability point that the suit is required to be heard by the commercial.
Why? What was the valuation in?
But commercial,
It's not a commercial.
this is my lord.
We'll take up expert and pass the judgment. The din.
Defamation.
Defamation commercial.
Therefore, on the last occasion,
commercial কি আছে?
No. Last occasion, my lord, adjournment was sought by the respondent when my lord fixed it for hearing without paper.
Without paper books, yes.
Plaint is at page 39 of the application.
Oh. Nine a plaint. কি রে ভাই আমার মিনিমাম আইডিয়া নেই this was a suit for money suit for defamation by the advocate against the client or
Against the bank.
Bank was your client
But actually,
or deletion from the list of their panel or something.
yes.
Anyway, whatever way it goes, commercial matter, it was dismissed.
They took the point, my lord. They filed the application.
Huh.
It is at page 53. Take it at page.
No, the order on Rule 10 was filed.
Yes. Order 1 Rule 10, subsequently, page 55, my lord, application under section 151.
Yes.
Order 1 Rule 10, my lord, they prayed for deletion of the defendant number 1 to 3. Page 55, my lord, application.
Commercial Courts Act একটা কপি দাও দিন তো Commercial Courts Act সেকশনটা কোড করে অ্যালাউ করে দিচ্ছি Where is the judgment? The memo is fine. No, but on merits also it was dismissed. But then he says about maintainability. Yes, ultimately. Oh, failed to prima facie prove that due to above. দেখে রাখা ভালো গৌরব ঘোষ
Prior to that, by the order dated.
This was a date for hearing the application.
Is your lordship kindly?
Yes.
Page 57 of the application, order dated 18th February 2022. Well, it is directed that the appeal will be heard on maintainability.
But preliminary issue was fixed on maintainability. So therefore, the
Issue number 1.
issue number 1. Therefore, an issue was framed and you were heard and that issue was decided. So he could have done that.
Yes.
He held that the suit is not maintainable.
Yes.
So it was just because it was for hearing on the issue of maintenance, not a date for hearing of the application only. For hearing on the issue of maintenance. So issue was framed and decided. On that he was not at fault.
But issue is whether it will be placed before the commercial.
No,
Not-
preliminary issues framed in the first page of
Yes.
the impugned order.
Yes.
Whether the suit is maintainable in its present form and prayer.
Therefore, the issue maintainability is not that otherwise it is not maintained. It is not maintainable because it is required to be placed before the commercial.
Yes. But even that it should have been sent to the commercial court. Even if it was a commercial matter, could not have been dismissed like this. Either the plaint could have been returned or.
But it is not even a commercial.
No, on that count, yes. At the time of call, comma, none appears to represent the respondents. First up, we find from our order dated March 12, 2025, that an adjournment had been sought on behalf of the respondents on the said date as well. First up, we had recorded in the said order that in view of the short conspectus of the appeal, comma, as enumerated therein, comma, the appeal would be heard on the papers already on record without filing formal paper books. First up, since the respondents choose to abstain from the hearing even today, comma, we take up the appeal for hearing in the absence of the respondent. First up, next para. The appeal has been preferred on a very short point. First up, in a suit for defamation filed by the plaintiff stroke appellant, comma, an application challenging the maintainability of the same was filed on behalf of defendant stroke respondent number 4, comma, on the ground that the matter pertains to a commercial dispute and as such should be heard by the commercial court and not the regular civil court. Push up next para. By the impugned judgment and decree, comma, an issue as to maintainability was, comma, inter alia, comma, framed by the learned trial judge, and the learned trial judge dismissed the suit as not maintainable in the ordinary civil side of the court. For sub next para, learned counsel appearing for the appellant argues that a suit for defamation cannot be classified as a commercial dispute from any perspective. Full stop. Even otherwise, comma, the date on which the suit was dismissed was fixed for hearing on the issue of maintainability. Full stop. Next para. It is pointed out that the maintainability, that the suit is maintainable in all respects. Full stop. Next para. Upon a careful perusal of the materials on record, comma, we find that in the application under section 151, challenging the maintainability of the suit, comma, it was merely pointed out that the amount as claimed by the plaintiff is beyond the pecuniary jurisdiction of the court in terms of section 3 within bracket 1 of the Commercial Courts Act 2015. First up, the learned trial judge, comma, without adverting to the meat of the matter, or even without adverting to the definition of double inverted commercial dispute in the 2015 Act, comma, by a one-liner, comma, held that he was of the opinion that the plaintiff failed to prima facie prove maintainability of the suit or having sufficient cause of action, and as such decided both the preliminary issues, comma, as to maintainability and cause of action, comma, against the plaintiff and dismiss the suit. Full stop. We are rather shocked by the above approach of the learned trial judge. Full stop. Insofar as dismissal of the suit is concerned, comma, in any event, the learned trial judge went dehors the law in dismissing the suit on the ground that the plaintiff did not have sufficient cause of action at the threshold, comma, by framing a preliminary issue thereon, comma, without permitting the parties to adduce evidence in connection with the suit. Full stop. Even in the impugned judgment, comma, the learned trial judge records that such findings were prima facie. Full stop. Thus, comma, the learned trial judge could not have dismissed the suit itself on such prima facie findings. Full stop. Next para. The question as to whether the plaintiff has sufficient cause of action can only be decided upon a regular trial, comma, upon considering the evidence adduced by the parties and not at the outset, comma, as opposed to a situation where a plaint can be rejected if no cause of action is italics say disclosed. Full stop. The learned trial judge did not find that no cause of action was disclosed, but framed a preliminary issue on the question as to whether sufficient cause of action was there. Full stop. Next para. Apart from the fact that such issue could not be formulated within the contemplation of Order 14 Rule 2 of the Code of Civil Procedure as a preliminary issue, comma, since mixed questions of fact and law were involved, comma, the said issue was also decided erroneously, comma, on the basis of prima facie findings, comma, without granting any opportunity to the parties to adduce evidence. Full stop. Next para. The learned trial judge acted with palpable illegality on the other issue of maintainability as well. Full stop. The Commercial Courts Act 2015, comma, in section 2 within bracket 1 within bracket small c, specifically defines a commercial dispute, double inverted মধ্যে. Full stop. Next para. A suit for defamation does not come within the purview of such disputes at all, comma, there being no commercial element involved. Full stop. The learned trial judge proceeded on an erroneous premise that merely if the valuation of the suit was above the pecuniary limit, was above the specified value, double inverted with the specified value, as defined in section 2 within bracket 1 within bracket small I of the 2015 Act, comma, the same would be captioned as a commercial dispute. Full stop. Next para. On a careful perusal of the plaint, comma, we find that the cause of action of the suit in comma as disclosed in the plaint, comma, entirely revolves around the allegation of defamation of the appellant by his client, comma, the respondents, comma, and there is no element of commercial transactions at all. Full stop. Next para. A claim for defamation cannot, comma, under any stretch of imagination, comma, be held to be a commercial dispute as such. Full stop. Next para. Thus, comma, we are of the considered opinion that the learned trial judge erred in law in dismissing the suit as being barred by law, comma, since it was a commercial dispute. Full stop. Next para. Accordingly, FA number 70 of 2023 is allowed ex parte against the respondent, comma, thereby setting aside the impugned judgment and decree dated December 16, 2022, passed by the learned civil judge, senior division, second court at Paschim Medinipur, comma, district Paschim Medinipur, in money suit number 62 of 2019, and remanding the matter to the learned trial judge for adjudication of the suit on a full-fledged trial on its own merits upon giving adequate opportunity to both sides to adduce evidence and advance arguments. Full stop. Next para. It is expected that the disposal of the suit shall be completed as expeditiously as possible, comma, preferably within a year from the date of communication of this order to the of this judgment to the learned trial judge. Full stop. A formal decree be a formal no order as to cost. A formal decree be drawn up accordingly. তার নিচে can 1 of 2023 is disposed of consequentially as well. Thank you. শুনবো রিসেসের পর একটা 2 PM আছে। হ্যাঁ 2 PM এ তো আর কোর্ট উঠেই যাচ্ছে না, আমরা তো বসছি আবার 5 ওভার মানে পরে নেবো। আপনি ওই 2 PM ফিক্সটা
Let,
Yes.
90, I appear for the appellate, my lord.
This
My
was the
lord,
mentioned matter.
my lord.
Yes.
My lord, suit for partition, my lord. My prayer for identity injunction was refused, my lord.
Why refused?
My lord, it was refused on the ground that there has been a delay of 1 month, my lord, in approaching the court because the learned court held that. Lordship, the last portion of the order, my lord.
Morgan Stanley.
In the instant case, the plaintiff has first notice of the alleged act of the defendant on 14/3/2025. The application of the temporary injunction is moved about 1 month thereafter. In these circumstances, I have the opinion that an interim order should not be granted. Well, it was moved on, my lord, 16th of April, my lord, the application was made. Well, within.
There is no caveat.
Okay.
The present appeal arises out of the refusal to grant ad interim injunction to the plaintiff stroke appellant in a suit for partition. Full stop. The learned trial judge refused to grant such injunction merely by quoting Morgan Stanley Mutual Fund versus Karthik Das, reported at 1994 4 SCC 225, observing that there was a delay of about a month from the first notice of the infraction of the plaintiff's right and approaching the court. Push up next para. However, since in a partition suit, creation of third-party interests might adversely affect the interest of the parties, and the properties ought to be preserved in statu quo during pendency of the suit to avoid irreparable injury at the culmination of the suit, and also keeping in mind that in a partition suit, in respect of injunction, the cause of action is continuous, we are prima facie of the opinion that sufficient ground for injunction was made out by the appellant. But regarding this collection of rent, we will not grant injunction.
My lord. Well, that has to be heard, my lord.
Although regarding collection of rent from the tenants, we are of the opinion that such injunction cannot be granted at this stage before hearing the other side, we are inclined to grant injunction with regard to the other prayers made by the plaintiff stroke appellant. Accordingly, the appeal is admitted and shall be heard on the grounds taken in the memorandum of appeal. Full stop. The rest only against defendant number 1 injunction.
My lord, defendant number 1 and 2, my lord, both are part.
So why pro forma?
Pro forma, my lord, because my lord, defendant number 2, my lord, we have came to know that he was intending to purchase a portion of the property.
Acha, the defendant stroke respondent number 1 and pro forma defendant stroke respondent number 2 and or their main and agents shall remain restrained by an order of injunction from changing the nature and character of the suit property and or from creating any third party interest in respect of the same till disposal of the present application. The appellant shall serve copies of the injunction application on the respondents, on both the respondents, indicating that the application shall be listed for hearing on June 16, 2025, when an affidavit of service to that effect shall be filed by the appellant.
With regard to item number 50, my lord, I mentioned this matter. We did not get the paper books from the.
Yes, we had a talk with the department. Your vocalatnam is defective. We did not say. You have to file a proper vocalatnam first. Otherwise, no appeal paper books can be served on it.
I'm the respondent.
Yes.
It is the mistake of the appellant who did it. He has.
No, your vocalatnama.
No, I have.
We tallied. The file was brought to us because of you. We tallied with the trial court's decree. The name, the recording of the name in the decree does not tally with your vocalatnama. It is not the appellant's fault.
No, this is the Oshit
ASHIT you have signed, your client has signed.
Not signed in the
In the trial court's decree, whatever is the name in the trial court's decree, you have to file vocalatnam in that name. Otherwise, you had to apply for correction of the trial court's decree there. We cannot go, we have to go by the trial court's decree. When we were in practice, we used to file vocalatnam by saying alias. I don't know what is now being done, but you have to take steps. We cannot, the paper book cannot be served by you. And we applauded the department people because they stood on their firm on their ground despite hearing that the judge has given leave. because they would be wrong in giving you that wakalatnama. File a proper wakalatnama and to get your paper book. You should have pointed that us in the morning.
No,
There's
I was,
a report by the office.
no, they have sent a report, I think. But
You should have pointed that out.
I was telling they have made a note, but this is the
No.
and this is not my fault. That is the thing. I had signed.
Whoever's fault, you have to file a proper wakalatnama before getting a copy.
I don't know.
এখনো করা যাবে না, ছেড়ে দিই। ক্যাভিয়েট তো নেই, এমনিতেও কোনো অসুবিধা নেই। Yes.
Sorry, my lord.
No, no, why, sir?
When the matter was called,
Yes, Mr. Putta. You said it's a very short point. So what is the point?
Very short point is, my lord. Plaintiff, appellant, defendant in this matter, my lord, he obtained a decree against his tenant.
You.
I. And the present respondent, who is the brother of that judgment debtor. Decree is squarely binding upon him. My lord, he surreptitiously.
By binding upon him, he can claim an independent right.
No, he having no independent right. He was with him
Achha,
as a family member.
Then what happened?
And he obtained this decree against. He filed a suit against my father. In the year 1989. In the year 1989, my father also died.
Your father had obtained that decree against his brother?
Yes. And the suit was filed against my father. My father died. Thereafter, there was no substitution. We had no knowledge about that. He obtained the decree. He obtained ex parte decree restraining me to execute the decree.
No, substitution was effected then.
No substitution, no papers.
Decree was obtained in the name of the father.
No, in our name.
Then must have been substituted.
There was no record, no service at any point of time.
That is a different thing. No service and no substitution are different.
Now he obtained the decree and he get it.
What is the decree he obtained?
He obtained the decree restraining me from putting the decree into execution obtained in my suit.
Why? They pleaded fraud?
No. They pleaded that he had not been impleaded.
So then he could have preferred an appeal against the. Let us see. No, why? Order 9 Rule 13?
Order 9 Rule 13 dismiss. Or in Order 9 Rule 13, there was delay of about.
So we cannot go into the merits of the suit. Your Order 9 Rule 13 has been
Section 5.
And consequentially, Order 9 Rule 13.
Yes, since we had no knowledge and we obtained knowledge when they judgment data preferred on civil divisional application against the order of execution. At that time, the petitioner judgment data show that there was a decree that can be the present decree which we obtained that can be executed. That is the source of our knowledge.
Let us see the impugned judgment first, Mr.
Yes.
Kota. Your section 5, what was the delay?
Delay about 6 years. 6 years. I'm saying.
So at the section 5 stage, evidence was taken?
Yes.
Why yes like that? You also had to say evidence. Show us the impugned judgment, Mr. Kota.
It is in page number 44.
You take your seat. You'll get your turn. Yes. Let us see the impugned judgment. Why was it dismissed?
Both parties filed. May I go through the entire judgment? Both parties
So
felt
it's written no oral and documented evidence has been adduced. So what have you annexed that evidence? No, this is the judgment is dated the 22nd of December 2021.
Yes.
Court observes at page 50 no oral and documented evidence. Then what evidence you have annexed?
Well, let me go through the judgment.
You are not ready, Mr. Poddar.
Can't
even say this, answer
my,
this simple
my
question.
lord, my contention is, my lord, for that reason I pleaded before your lordship. The point is very short because the whatever the judgment I obtained, eviction decree which I obtained in a suit filed in ejectment suit.
We cannot look into the merits of your
the suit is not maintainable because no independent.
Cannot look at that unless your order you cross the hurdle of section 5 and ordinance rule 30.
Yes.
So it's not at all short.
Yes.
The judgment itself is of
yes, judgment
14
is
pages.
lengthy one.
In an ordinance rule 13 application, 14-page judgment, it's a short matter. And there is evidence adduced. We find evidence annexed here, but the court says no evidence was adduced. You have to explain that also.
Evidence was there.
Please come to page 50.
No oral and documentary evidence have been adduced by either of the parties here too. Now, learned advocate acting for the petitioner herein submitted that here this court itself stated that both the
Suppose the come prepared in the matter. Court says why? Can you throw some light on this? Was evidence adduced actually?
There is a PW1.
We are finding evidence annexed here.
Page 25 affidavit in chief.
We are finding not only that clause also.
Yes.
There was 32 deposition of PW1.
But court says no oral or documented evidence. That itself is a ground for setting aside. Page 50, second last paragraph, penultimate paragraph.
Yes,
court says no oral and documented evidence has been adduced by either of the parties.
And page 25 is my evidence. Under 6 of the limitation, under 5 to 6.
And court goes by the submissions of parties and judgments also.
But page 26, my 25.
Again, page 55, it stated here PW1, although an educated person.
Yes.
So that must be a wrong recording or wrong statement. Yes, are you prepared on the merits of the case, Mr. Poddar? Come prepared on the merits. We won't look into the merits of the suit. How can we look into that? You have to cross the hurdle of section 5 and ordinance rule 13 first. Come prepared on the merits of the case. Although on the last occasion it was submitted by learned counsel for the appellant that the matter is on a very short point, we find that the present appeal has been preferred against a judgment whereby an application under ordinance rule 13 of the Code of Civil Procedure has been consequentially dismissed upon the connected application under section 5 of the Limitation Act being turned down. First up, the learned trial judge took into account evidence adduced at length by the parties, and as such, a short hearing at such, the matter requires a lengthy hearing. So be that as it may, learned counsel for the appellant seeks to impress upon the court that the ex parte decree, in connection with the application under ordinance rule 13 was filed, was itself bad in law. Full stop. However, we are unable to look into the legality of the ex parte decree itself unless the appellant crosses the hurdle of section 5 of the Limitation Act and thereafter the application under ordinance rule 13 of the Code of Civil Procedure, both of which were dismissed by the impugned judgment and order. Full stop. Let the matter be listed for hearing after the upcoming summer vacation.
Well, there is one application, filed on my behest, under order 41 rule 27,
Then we will direct affidavits to be exchanged in the meantime. That application is appearing today.
Yes, 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 yes.
What?
But this is can 3 of 25. Copy has been also served.
Acha, very well. Affidavits in respect of can 3 of 2025, comma, if any, shall be exchanged in the meantime.
Great.
Exchange affidavits, Mr. Poddar, and come prepared.
Great.
Item number 33.
I have informed the respondent's advocate, learned advocate. He will come. May not.
Oh, you're for the appellant, yes.
Yes, yes, Lord.
I can start the matter, Mr. Chakraborty.
But they are deliberately avoiding. Actually, my lord, what happened, my lord? This is a suit by husband suit for divorce on the ground of cruelty and desertion. My lord, in the conciliation proceedings before the trial court, the wife did not participate, and thereafter, only steps he has taken, filing the written statement. Thereafter, nothing. Did not cross-examine my
Cruelty or desertion also?
Cruelty or desertion.
Both.
Cruelty and desertion. But since 2012, she is not has left.
Any child of the marriage?
One boy, one male child. He's become now MBBS passed out. What happened, Milord? The thereafter, Milord, written statement filed. Did not take any steps further. Did not cross-examine the sole witness, PW1 husband. Did not lead any evidence. And the suit was heard ex parte. And even thereafter, it was dismissed. Now, dismissal was on some peculiar ground, my lord. I shall place the judgment, my lord. First of all, my lord, there is no in the written statement.
You alone adduced evidence on your behalf.
My lord?
You alone adduced evidence on your behalf.
Only PW1. Only PW1. So nobody comes to contradict actually. Anyway, in a written statement, my lord, you'll find that it will sufficient ingredients of cruelty and desertion.
So
has been
why
made.
not? Why was the suit dismissed?
Suit dismissed on.
Should you start with the judgment? Then you will know what to look for in your.
Lord, before that, my lord, only short. I am just.
Yes,
I shall propose the judgment. What happened, Lord? The judgment is in the written statement is a mere denial, nothing more. General denial, no specific denial. Just reproduction of the statements and denial. No, nothing was, no reason has been assigned why he has deserted the husband and nothing. And no counter allegation also. But the learned judge has found that I have driven her out from the matrimonial home along with the child, denied her maintenance, all these things. Some totally perverse finding.
Maintenance application was filed in
nothing, but she is drawing three
times
greater than. He's an associate professor of IISWBM, leading institution, management institution, just before Indian Institute of Social and Welfare, and my client is a upper division clerk of railways. Anyway, that's why no question of. They're not interested. They are not interested in husband's money, but they are not interested in husband discharging matrimonial relationship. But
what was the nature of cruelty we alleged?
Nature of cruelty, denial of matrimonial relationship mainly.
But the son was born. Son was born.
Son was not.
Yes. Son was born. So matrimonial duty not as in
no, not that. But anyway,
what matrimonial duty?
He is not desertion itself. He is not allowing her son to husband to meet her husband.
Mr. Chakraborty, should we read your allegation on desertion and her written statement?
Yes, yes.
I think we think that will be a good starting point.
Before may I place the judgment first? Not
whichever way you want to go. Your appeal?
No, kindly.
You do it in your own way.
May I place the application? One more thing, Lord. Learned court has weighed with the court, weighed with the learned court. The consideration is the rising number of divorce in the present day society. These are the factors. Matrimonial bonds should be sanctity of matrimonial relations should be maintained. Fabric of moral fabric, social fabric is damaged. These are the considerations. These are the way with the learned. Totally perverse findings which are not borne out on the record, that I have driven out. Nothing, no allegation at all. In the only version available is the written statement, nothing. Kindly come to page 2 onwards. Page 2 onwards.
Yes.
On
8th March 2000, the marriage between the petitioner and the respondent was solemnized according to Special Marriage Act 1954 before the marriage officer, Amita Mani Bhumlik, etc., Barakpur, subdivision, etc. Then come to 2, that after marriage, the petitioner and the respondent started living together as husband and wife, and the petitioner's house at 26 Anadnath Lane, Calcutta. That the parties were blessed with one male child born on 26 January 2002, named Shubhradeep Mitra, renamed Obradip Mitra. That the respondent was warmly welcomed at the matrimonial home and was being treated with the utmost love and affection by the petitioner and his mother and other relatives. Initially, conjugal life of the parties were more or less peaceful and happy. That your petitioner never neglected in the discharging of duties as a husband. He was all along cautious about comfort, pleasure of his wife, always tried to maintain her
Oh,
properly.
after the delivery of the child, she never came back.
No.
She was taken to her paternal home at the time of delivery.
No. Thereafter, even thereafter. Thereafter came.
Oh, thereafter came.
subsequent.
Let's see.
Not what happened, Milord?
We have read up to para 8. You
Paragraph-
increased your frequency
paragraph-
of visit. Up to para 8.
Para 8.
Son's birth, she was there since then.
Yes. That they, after the birth of the son, I'm placing from paragraph 8, that the birth of the son brought a flow of joy in the matrimonial house. Petitioner and her mother were overflooded with joy and started patiently waiting for arrival of the respondent with the child at the matrimonial house. After son's birth, the petitioner increased frequency of her visit at the maternal home, discharged his duties and responsibilities as the husband as well as the father, time to time arranged medical checkup for his wife, child, and contributed for their maintenance. That though the petitioner left no stone unturned to make his wife happy and maintain his wife, the child properly to the best of his capacity, the petitioner shockingly observed that the respondent was getting radically changed day by day out of her inherent dominating character and superiority complex. The respondent started ignoring and neglecting the petitioner. She never gave any importance to the petitioner's opinion in any matter and never discussed the
That
petitioner.
Mr. Chakraborty, every spouse is guilty of that.
Yes.
These are very general.
No, Milord, these are the.
Where do you find a spouse who honors every opinion of his or her other spouse and
But these are
does not
there
try
are
to be
there are
dominant?
judgments that these are also
These are
considered. as-
normal wear and tear of matrimony.
No, even after-
Insulting, you have
But desertion is
dominated
not-
the petitioner.
Desertion
May
is
dominate
there.
the petitioner.
Desertion is there, blood, from 2020. And not only that,
What's the instance of desertion first?
uncontroverted
Hmm.
evidence. Uncontroverted.
Where is the
debate.
first desertion? Let us see that.
Desertion, the respondent all along dominated the petitioner. I'm saying desertion, but even after
Insulting, defaming, you have stated
No,
in
I-
public.
even
This we
there
can
kindly
understand.
come to paragraph 9, blood. No, a later part of 9, blood. The respondent all along dominated the petitioner and imposed her own feeling and whimsical decision. The respondent also started insulting and defaming the petitioner. No, this is not the common.
This
thing.
is what we are saying.
Not expected
This
also.
insulting in public also you have said.
He did not. These are uncontroverted. He did not hesitate to
We'll
insult,
see whether
defame, and
these are-
humiliate the petitioner before others, even in public, and doing so, she used to get enjoyment. By continuously talking adverse about the petitioner, the respondent also continued imparting with their son ill feeling about the petitioner. But these are also ingredients, teaching the son to hate his father and the petitioner. That even after being seriously humiliated, the petitioner repeatedly requested the petitioner respondent to come back, but she preferred to stay back at the paternal home on one or the other pretext. However, the petitioner continued his effort to bring her back. After a lot of efforts, the respondent agreed to spend weekend at the matrimonial home. Accordingly, she started coming to matrimonial home at the night of Saturday and leave the early morning on Monday. This practice continued till sometime in the third week of 2012. Thereafter, the respondent stopped visiting matrimonial house on the pretext of her ill health. However, the petitioner continued discharging her duties and pursuing the respondent to come back permanently with her son. Thereafter, para 11, that in the meantime, the petitioner also went to a trip to Bangkok with the respondent. After the respondent stopped visiting matrimonial house, third week of June 2012, the respondent started expressing her irritation over petitioner visiting her paternal house. Though she allowed the petitioner to meet her outside the paternal home, but declined to allow the petitioner at the paternal home. Kindly, this is the allegation, not statements, and mere denial in the written statement, and same allegation made in the affidavit in chief, not uncontroverted. No counter evidence also given. The petitioner continued meeting the respondent as and when at the place he wished, and meet of her requirement. The petitioner shockingly observed that days after days, though after meeting the petitioner accompanied the respondent up to her paternal home, but she never asked the petitioner to enter into the paternal home. Even her parents also never asked the petitioner to enter their house. It also happened that the petitioner himself repeatedly expressed his desire to go to her paternal home, especially to visit and talk to his son, but the respondent declined. The petitioner swallowed such shockingly and painful treatment, humiliation, and insult, patiently with the hope of the better days to come. But unfortunately, with the passing of days, the respondent also started expressing irritation over petitioner's contact, either personally or over phone, and by her words and gesture made it clear that she do not like this practice to contact with her. The petitioner was not allowed to talk and interact with his son. Then para 13. That even after being ignored, the neglected and humiliated, the petitioner continued his effort to contact and convince her. The respondent started expressly shocking her disliking towards the petitioner and expressing suppressed threats. Gradually, the respondent started openly expressing that neither the petitioner nor his family was up to the mark of her expectation, choice, status, and standard, and that she was not expected to spoil her life by continuing the marital tie with the petitioner, who, according to her, is a person belonging to the lower status than her. The respondent started behaving with the petitioner rudely, expressed annoyance, anger, and irritation over his visits. That due to the act of the respondent's desertion and being unable to visit his son, the petitioner and his mother was seriously shocked. The petitioner's mother received serious shock. Ultimately, when despite repeated efforts and attempts, the respondent did not come back, the petitioner's mother broke down mentally, became ill, and suffered cerebral attack on 14th September 2014. Immediately, she had to be admitted in Arjikot Hospital. On being informed, the respondent came to hospital only for 10 minutes and left. Despite repeated approaches and knowing well that the petitioner was completely alone, helpless, and the respondent refused to stay at the side of the petitioner and even did not take any information about his mother, her mother-in-law also. Since thereafter, condition of the petitioner's mother went on deteriorating day by day and had to be shifted to nursing home and hospitals for quite a number of times. But despite being informed, the respondent did not feel any urge to come back and support the petitioner. When discharged from the nursing home or hospital, the petitioner had to keep his mother at the maternal uncle's house, since there was none in the petitioner's house to look after his ailing mother, as the petitioner had to leave for office. During her stay at the petitioner's maternal uncle's house, once the respondent visited the petitioner's mother along with a son only for a few minutes and returned to the paternal home. Besides petitioners, his relatives also repeatedly approached the respondent to come back, at least for the sake of the petitioner's bedridden mother, but the respondent did not pay any heed to anybody's request. Then, Milord, 15, it is important that after the respondent left and stopped visiting matrimonial home sometime in third week of June 2012, despite repeated emotional approach made by the petitioner, the respondent never spent night with the petitioner and allowed physical relation with her. This is also not a settled law. Note that never allowed the petitioner to enter into her paternal home and stay there. But by her words and gesture, the respondent also refused to cohabit with the petitioner and denied marital rights of the petitioner. Since the respondent never agreed and allowed the petitioner to live cohabitation with her, there has been no physical relation between the parties after third week of June 2012. More than 13 years now. That the petitioner continued informing the respondent about the petitioner's mother. The petitioner also informed her that the condition of his mother was critical. On 20th October 2014, by SMS, the respondent inquired about the condition of the petitioner's mother and visited her hospital for a few minutes. On 21st April 2014, in the morning, the petitioner's mother expired at BR Singh Hospital. Then, on receiving information, the petitioner's mother's death, the respondent came to the matrimonial house and without being involved in any manner, stayed still such ceremony. During this period, the petitioners repeatedly tried to make the respondent understand that after his mother's death, the petitioner has none of his own to save and accept the respondent. The petitioner repeatedly requested the respondent not to leave him alone. The petitioner also repeatedly tried to make the respondent understand that their living together is also essentially necessary and in the interest of the future flourishing welfare and well-being of their only son. The petitioner's other relatives also repeatedly requested her to stay with the petitioner and not to leave him helpless and alone. But after a few days of her arrival, the respondent started expressing about the difficulties, hardship, and increasing expenses in attending the college from the matrimonial house, and with the said plea, she continued frequently staying at the Salt Lake. Salt Lake is their father's house. On 19th November 2014, the respondent left the Salt Lake on the plea of certain urgent work. During this period, though the respondent stayed at matrimonial home, but there was no cohabitation between the parties. Only for a few days he came on the death of his mother-in-law. And the respondent did not allow the petitioner to have cohabitation with her. Now, these are the uncontroverted, unrebutted allegations, both in plain and written evidence in chief. Thereafter, suddenly on 23rd November 2014, the respondent came to the matrimonial house, and after a few moments, she adamantly left with all her belongings, bags and baggages, ignoring repeated requests and emotional approaches made by the petitioner as well as the elderly relatives not to leave. While leaving, the respondents even did not hesitate to falsely blame the petitioner of having relation with other female as an excuse for her leaving, causing serious mental shock to the petitioner. Paragraph 18. False blame of some other relationship. The name of the petitioner's son was mutually unanimously decided as Subhrati Mittal. The name was changed. It is not a serious allegation in paragraph 9. That 20 minutes, kindly come to paragraph 20. That after she left the petitioner's house, after such ceremony of the petitioner's mother, the respondent started totally avoiding contact with the petitioner's contact. She stopped receiving petitioner's phone and stopped meeting with the petitioner. The petitioner was also not allowed to visit her at her paternal home. The respondent started giving threats to the petitioner with dire consequences, refused to come back, and further threatened the petitioner not to visit her again. Despite his repeated efforts and attempts, the petitioner could not establish contact with the respondent in any means due to her unwilling and denial attitude and suppressed threats. Being unable to convey his feelings, emotions, anxiety, agony to her other personally face-to-face over phone, the petitioner was constrained to write a letter sent under speed post, posted on 16 May 2015, stating typographical errors, everything in details, and again requesting the respondent to come back in the interest of their conjugal life and for the betterment of their only son, and urging upon the respondent to convey her decision if she was determined not to return. This is admitted evidence that even after the said letter, the respondent neither come back nor responded to the said letter. On the other hand, since thereafter the respondent started continuously threatening to implicate the petitioner in false criminal case and get him arrested by police if the petitioner dared to make any further attempts to take her back or even make any further attempt to contact with her. Thus, by her behavior, conduct, and expressions, the respondent finally conveyed her determination not to come back and to lead conjugal life. That the fact and circumstances stated above disclosed, the respondent treated the petitioner with cruelties on her own accord and voluntarily left matrimonial home with her belongings, withdrawing herself from the society of the petitioner and deserting the petitioner without any reasonable cause, excuse or reason, and did not come back despite repeated efforts and attempts made by the petitioner. Finally, by her act and conduct, respondent conveyed a determination not to resume conjugal relationship, LVF to the petitioner. Well, these are the allegations. And similar allegation in the evidence in chief, not cross-examined and did not lead any evidence on our own. And in the written statement, he has mere denials, no specific, just general denial. I shall show, my lord.
Only two things she has stated in her written statement, that she was not spared from domestic work during her pregnancy. So to take care of her, her parents took her back there. But after that, there is no, apparently, apart from denial, there is no explanation why she stayed on.
Conduct of the wife, Lord, I am on
Yeah,
conduct
this,
of the wife, Lord. He did not participate in the conciliation proceedings. Thereafter, Lord, not participated in the trial in the strict sense, only filing written statement. And even, Lord, after filing this appeal, Lord, I will kindly come to paragraph page 67 of the paper book, the order dated my Lord Justice Sen and my Lord Justice Kumar was also party of this bench, my Lord. On 10th April, matter was sent for mediation. Page 67, my Lord.
Yes.
67.
67, 68, 69.
67, 68, second
What
page, my
happened?
Lord.
Failed mediation.
We appoint Mrs. Suparna Mukherjee. It was sent to mediation.
Page 71 is the mediator's report.
Mediator's report was filed, my Lord. What happened, my Lord? It was recorded in the subsequent order, page 73. Kindly come to page
Conduct of the
73.
respondent is undesirable. In spite of notice, did not participate in
No,
mediation.
it's not 73, 71, my Lord.
71, yes.
71.
That is what we are reading.
The report is with my Lord's file, my Lord. I have no access to it.
No, this is the recording of this court. 10
And my Lord felt that his Lordship felt that court may penalize the petitioner, respondent, for not participating.
Where is that?
In this page 72. Page 72, just penalty.
Complete copy of, yes.
Not certified copy, not paper book.
No, not certified copy. Yes, complete copy.
Page 72. This is the conduct. They are deliberately avoiding.
Where is it penalized?
Last para, we may penalize the respondent for not participating in the mediation proceeding in spite of our order and the report filed by the learned mediator in this regard. But, my Lord, kindly peruse the mediation report, my Lord. It is lying with your Lordship.
Obviously, she did not participate. Otherwise, this finding would not be there. And what about the evidence? Your chief is there. Chief must be the corroboration of this.
Corroborating and nothing, not rebutted,
No cross-examination. Let us see the judgment now.
Judgment, kindly.
You need not read the narrative portion, Mr. Chakraborty, because we
Page
have already read
46 of the paper book.
Page 46. Yes.
Page 46.
Plaintiff case we skip over.
Today is fixed for further evidence. Further evidence of the PW1. The petitioner is present by filing Hajira. The respondent is also present by filing Hajira. On behalf of the respondent, a petition has been filed for paying for time to take necessary step. The said petition is not moved on call. The petition for time stand rejected. The record is taken up for further examination of PW1. PW1 is examined and two documents are marked as Exhibit 300. Documentary evidences are not relevant in this case. Only something identity, proving of identity, or learned advocate for the petitioner submitted that his evidence may be closed, and as there is no evidence left on behalf of him, in such view of the matter, the evidence of the petitioner is closed. Heard the argument on behalf of the petitioner, the record is taken up for passing the necessary order. On the same day, it was taken up for the order. That in an application under section 27(1)(b) and (d) of the Special Marriage Act, filed by the petitioner Avijit Mitra against Shrimati Deepa Mitra, the address of the petitioner was written in the petition as 26 Anath Nath Dev Lane, PS Talam. This is not relevant. Can we come to the next para? Plain case in brief is that the marriage between the parties was registered and solemnized according to Special Marriage Act, and social function was held on 5th July 2000. After that, they started to live together as husband and wife and the matrimonial home, and the parties were blessed with male child. It was recorded. Only now, next, it is important. Next part is
this
important.
This is a common refrain of this judge. Mr. Chakraborty, you have come across at least 3 judgments, copy paste of the same thing.
Reasoning has been given in the
page
next
53 onwards. Page 53, please come to page 53. Same
page 53.
Thing. Page 53. It starts at the middle. Page 53, just about the middle of that. So looking at that perspective, the story of cruelty rendered by his wife to him seems to be very dubious. Because why? Because he says, no doubt the lady did file complaint, and as a progressing
Lady
action-
did file complaint as a progressive. No complaint was filed on behalf of the lady. It is totally misreading of the records. Totally misreading.
how far it is ironical to the lady, or it is so
May I
fortunate to the
place the
husband?
judgment from first part when it will be will find totally extraneous consideration.
Same thing. Indeed, what was being the task of the husband to pacify the rage and anger of the wife? You did not even have the time to see her rage because she left you. That is your case.
No complaint of the on behalf of
Same thing. We are seriously wondering whether we should give a caustic remark here. Same thing. Quite reasonable and sensible to appreciate even in a trifling difference of opinion, parties can. Same thing. There must be a reasonable and sensible role from the side of the husband to bridge the gap. Same language.
Facts of some other case, maybe.
Tell
some
his
facts of-
imagination. Not some other case. This is a common. He has a template probably.
But it is not from the record. Record it is something.
No, he has a separate his own record, a
Own
template.
record.
The judge.
I understand. And last part is very important, Lord, when the sanctity of the matrimonial relationship.
He just started
What
from-
is the ideal husband-wife?
Yes, same thing.
This type of discussed. And these are the consideration where with the land.
Very correct. Ekdam same. Wife is fond of making derogatory and ugly remarks against her, which amounts to mental cruelty. বলছে mental cruelty. তারপর বলছে same thing. বলছে derogatory mental cruelty. তারপর বলছে
No application either
derogatory to the
apart from
husband,
this.
rather it was the helpless
divorce petition.
lamentation of the lady urging for a blissful happy life. Exact language, Mr. Chakraborty. Unfortunately, if we had the other judgments, it would be easier for us. Exact same line. Maybe the lady was somewhat discourteous, rude, and abusive.
Same learned judge.
Same learned judge. Same. With the sole object to cause genuine annoyance to her husband.
Copy pasting is draft. Learned
Plagiarism.
advocates, members of the bar are doing, and something is done.
Capricious desire to think so.
Some ridiculous things are coming out in copy pasting of drafting. Now we will have from
National,
judgment
at the
also.
national level. International, in fact.
Application of artificial intelligence.
In the circumstance, it is a fair expectation that the marriage is irretrievably broken down. Page 56 থেকে Oh. It was never her allegation. He says separation of the lady was a compulsion as her husband is guilty of his lustful attitude.
Lustful attitude. Never allegation. Otherwise, learned mediator also observed.
We shall
My
make
client
some-
said that how
No, it is a copy paste. We are
Copy
telling
pasting.
you.
No,
Same
lustful.
exact same language.
Both
Just
are
correct it and
good civilized citizen only. Not it is a fit case for irretrievable breakdown of marriage. Not my lord knows. Not it is not possible. I listen judgment of Somar Ghosh and other judgment.
Justice Dhulia's judgment.
Justice Dhulia's judgment. That judgment may be invoked. Principle may be invoked.
Indeed, the relentlessness.
Then coming to the picture, not can you see? Today I have also informed him. I said no instruction. I have got no instruction. This is advocate.
The present appeal has been preferred by the appellant husband against the ex parte dismissal of the appellant's suit for divorce on the ground of cruelty and desertion. Full stop. Next para. None appears at the time of call on behalf of the respondent. Full stop. Accordingly, we take up the appeal ex parte. Full stop. Next para. By the impugned judgment, comma, the learned trial judge overlooked the fact that the respondent wife did not adduce any evidence of her own, despite having filed a written statement, and also did not cross-examine PW1 within bracket the plaintiff stroke husband bracket closed full stop. That apart, comma, it transpires from a cursory perusal of the judge impugned judgment that the learned judge proceeded entirely on a tangential perception of his own, comma, without adverting at all to the materials on record. Full stop. In fact, comma, this bench has previously come across similar judgments by the same learned trial judge. And in the opinion of this court, comma, the learned trial judge is in the habit of using the same words and same syntax in different matrimonial suits, in judgments passed in respect of different matrimonial suits. Full stop. Such possibility is also borne out by the language used by the learned trial judge, and we are sure that if an inquiry is conducted, comma, it will be found that the self-same language has been used in matrimonial matters by the learned trial judge in several other suits as well. Full stop. The some of the words used by the learned trial judge are entirely dehors the pleadings of both the parties and creates a deja vu, DEGA view, deja vu in the mind of the court, comma, since we have come across the same phrases in other matrimonial judgments as well, comma, authored by the judge. Full stop. Next para. For example, comma, the learned trial judge, comma, in his judgment, comma, observes that no doubt, comma, the wife is fond of making derogative and ugly remarks against her husband, which amounts to mental cruelty, justifying the decree of divorce, but that it was the helpless lamentation of the lady urging for a blissful, happy life. Full stop. The learned trial judge further observed that, to his mind, comma, the husband who was not so careful to rectify the frailty conduct, double inverted, frailty, FRAILTY, conduct, double inverted close, of his own, then certainly it is open to criticism by his wife. Full stop. The learned trial judge goes on to hold that maybe the lady was somewhat discourteous, comma, rude and abusive in the matter of criticism of the CROCKED conduct of her husband, crooked, however, but it cannot be termed as unruly attitude with a sole object to cause genuine annoyance to her husband. Full stop. Again, comma, next para. Again, comma, the learned trial judge observes that no doubt the lady did file complaint as a progressing action to double inverted mudde, full stop. However, comma, it is surprising that such comment is even beyond the pleadings of the husband, comma, since the appellant husband only alleged in his plaint that threats of initiating criminal cases were issued by the respondent wife, but never alleged either in his pleading or in his evidence that the wife ever actually filed a complaint. Full stop. Next para. The learned trial judge held that how far it is ironical to the lady or it is so fortunate to the husband, he was not prepared to comment. Full stop. He further observed that what was being the task of the husband was to pacify the rage and anger of his wife. Indeed, as a matter of fact, from the evidence of her husband, nowhere it has been distinctly and clearly proved that he was really conscious to be tracked properly, within bracket, whatever it means, bracket closed. Full stop. Next para. The learned trial judge further gives his solicitous advice to the effect that although it is quite reasonable and sensible to appreciate, even in a trifling difference of opinion, the parties can desert themselves voluntarily for double inverted with the transactional period, double inverted close, but that in such circumstances there must be reasonable and sensible role from the side of the husband to bridge the gap. Full stop. Next para. The entire mindset of the learned trial judge appears to spring up from a patriarchal and condescending mindset, condescending approach, comma, thereby attributing a condescending role to the husband, comma, to advise his wife properly and also to condone cruel acts of the wife by trying to bridge the gap, double inverted mudde, between the parties. Full stop. Next para. Such observations have nothing to do with the law on the subject. Full stop. The settled law is that the court has to look at the conduct of the parties from their perspective and to come to a finding as to whether there is any cruelty, comma, either mental or physical, perpetrated by either of the spouses against the other, so as to make it impossible for normal conjugal life to be led together between them. Full stop. Next para. The learned trial judge, comma, not stopping there, comma, further advises that now further observed that it is a fair expectation that the marriage has irretrievably broken down, so a decree of divorce is being the legitimate claim of the petitioner. Full stop. The learned trial judge holds in his judgment that the husband is conspicuously silent what kind of nobility or morality he had rendered to his wife during separation period, leaving apart wife from her husband should not be the impurity with the aim and object of the conjugal life, but it can be safely concluded that separation of the lady was a compulsion as her husband is guilty of his double inverted with the lustful attitude, double inverted close full stop. Such lustful attitude, comma, unfortunately, comma, is not reflected even from the pleadings of the wife. Full stop. Next para. The learned trial judge goes on to say that practically speaking, the husband was never haunted by any compunction, comma, thereby putting to shame any fiction writer. Full stop. Next para. The learned trial judge further observes that there might be certain auspicious principles which he discovers could glorify the concept of a successful marriage in its optimum success. Full stop. The learned trial judge even formulates such auspicious principles, comma, the first of which is that transcendental efforts to keep a perfect relation based on austerity of the spouse for achieving purity of the relation is to be maintained. Full stop. The second dictum conceptualized by the trial judge is paying honor to our traditional belief. Full stop. Thirdly, comma, the learned trial judge puts forth an edict that there should be sincere interest in cultivating fidelity. Full stop. The learned trial judge, comma, fourthly, comma, says that there must be unmotivated and uninterrupted urge to completely satisfy each other. Next para. There are several other literary jargon used inappropriately and merely to flash the vocabulary of the judge without fitting in the proper adjectives in their proper place. Full stop. The learned trial judge even says that looking at the demeanor of the wife, he thinks it is not impossible to realize that the relief of feministic instinct, what is still left after decay, has every chance of reunion with the husband if he is awakened from his sleeping stage of doing vices and vulgarity. Full stop. The learned judge holds that at this stage, of it, refusal of it would be sagacious, SAGACIOUS, and impractical. Full stop. The learned trial judge discovers that the relentlessness of the husband is prominent, and he is doing so under a cognitive dissonance, and he intends to preserve this corrosive, CORROSIV, conflicts with his wife to have an order of divorce by hook and crook. Full stop. The learned trial judge found that no doubt many years have elapsed from the inception of the suit. Full stop. So, comma, despite lapse of long, despite that within double inverted, despite double inverted মধ্যে elapsation of long time, double inverted close, the judge did not feel it justified that an order of divorce would be positive solution or an efficacious relief when indeed the ground of cruelty is based on surmise and conjecture. Full stop. Next para. So, comma, he felt, comma, it is quite pragmatic and rational not to tilt the marriage knot, KNOT. Full stop. Ultimately, the learned trial judge, comma, prophetically, comma, observes that upon evaluation of the evidence and materials available on record, and then within double inverted objective assessment of reality, double inverted close, in the backdrop of the established facts, there cannot be any pinch of doubt that the husband has sought for this kind of remedy out of his double inverted মধ্যে erotic passion, erotic passion, double inverted close, and that is why his prayer for divorce is refused, when indeed this problem is the sequence of his incorrigible attitude. Full stop. Realistically speaking, comma, according to the judge, comma, the mind of the lady has been mutilated, yet she does not wish to relinquish her dream, the feeling of love to her husband, until now she has perceived that her husband will come to fetch her. Full stop. That is the last line of logic, of so-called logic, which is attributed to the judgment, comma, immediately followed by the ordering portion, whereby the divorce suit is dismissed. Full stop. Next para. Coming back from wishful fiction to the facts of the case, comma, we find that the plaintiff has categorically alleged several instances of cruelty, full stop. Out of those, comma, those which are German, out of those, comma, the German allegations pertain to the respondent wife insulting and defaming the husband in public and imparting within the son of the parties ill feeling about the appellant husband. Full stop. The husband has categorically alleged that the respondent stopped visiting the matrimonial house since the 3rd week of June 2012. Full stop. Next para. However, subsequently, on occasions, comma, it has been alleged that the respondent wife took information. Full stop. Next para. Despite coming to the matrimonial home, comma, the wife had come, comma, according to the plaint pleadings, comma, for a period of 10 minutes when the appellant husband's mother had a cerebral attack on September 14, 2014 and was admitted to the Arjikor hospital. Full stop. After discharge, comma, it is alleged in the plaint, comma, the mother of the appellant husband was kept in the appellant's maternal uncle apostrophe's house, since there was none to look after her at her home. Full stop. There was a single visit, comma, according to the plaint case, comma, by the respondent wife with the son for a few minutes. Full stop. Next para. The wife, comma, allegedly, comma, despite being informed of the critical stage of the mother thereafter, comma, only sent an SMS within bracket short messaging service bracket closed about the condition of the mother on October 20, 2014. Full stop. The appellant's mother met her demise on April 21, 2014, comma, after which the respondent wife stayed at the Shraddh ceremony. Full stop. As per the plaintiff allegation, comma, however, comma, the wife thereafter refused to cohabit and meet matrimonial obligations between the parties and left for her paternal house at Salt Lake on November 19, 2014. Full stop. On November 23, 2014, comma, according to the plaintiff allegation, comma, the wife came back but left with her baggage and belongings forever. Full stop. Next para. Certain other allegations have also been made in the plaint, comma, one of which is that the wife issued threats of initiating criminal cases against the husband. Full stop. We do not agree with the pleading of the husband that the wife having a hysterectomy operation without the appellant's consent was an act of cruelty, comma, since the respondent wife has every autonomy on her own physical existence. Full stop. Next para. However, comma, regarding the other allegations, comma, the wife merely uh, uh, made bald denials. Full stop. Such denials in the written statement are not coupled with any positive assertion or explanation and are found to be evasive in nature. Full stop. The only positive assertion made by the wife is that she was made to do domestic work even during her pregnancy, for which she was taken to her parental house by her parents. Full stop. Next para. However, comma, no explanation whatsoever is forthcoming, even in the written statement, as to why she stayed back and did not return to the matrimonial home and had cohabitation with and led a conjugal life with her husband thereafter. Full stop. Next para. Certain other important aspects also are required to be gone into. Full stop. First, comma, the wife did not lead any independence evidence in support of her defense case. Full stop. Also, comma, the wife did not cross-examine the cross-examine the husband, comma, who examined himself as PW1. Full stop. The examination in chief of the husband fully corroborates the plaintiff case, and as held above, comma, certain instances of mental cruelty sufficient to compel the parties to live separately and have their separate ways have been made out. Full stop. In the absence of cross-examination and independent evidence being laid by the wife, comma, the allegations should have been accepted by the learned trial judge as sacrosanct on the doctrine of non-traverse. Full stop. Next para. We further find from the conduct of the wife that the element of animus revertandi on her part is entirely missing. Full stop. Next para. The wife did not participate in conciliation proceedings and did not participate in the suit after filing her written statement before the court of first instance. Full stop. Not only that, comma, there was a previous order of this court whereby the parties were sent for mediation. Full stop. Next para. Surprisingly, comma, the wife abstained from mediation, comma, which prompted the coordinate bench, comma, in its order dated April 10, 2023, passed with the present appeal, comma, to observe that the bench may penalize the respondent for not participating in the mediation proceeding in spite of the order of the bench and the report filed by the learned mediator in that regard. Full stop. Despite the same, comma, the respondent wife has been repeatedly absent when the matter was called on for hearing and even today. Full stop. It clearly shows that the marriage between the parties has broken down irretrievably. Full stop. In cases where the current view, as per the current view of the Honorable Supreme Court, comma, in cases where the marriage between the parties has broken down irretrievably beyond repair and there is no animus displayed by either of the parties to return to their matrimonial life, the same should be treated to be cruelty by each of the spouses against the other, and if such a relationship is perpetuated with the blessings of the court, it would tantamount to cruelty being perpetrated to both spouses. Full stop. Next para. Keeping such view of the Honorable Supreme Court, taking such view of the Honorable Supreme Court into consideration, and on the above assessment of the evidence on record, we are convinced that the impugned judgment is not only perverse for having relied on extraneous circumstances, but also for not having adverted to the relevant considerations germane for adjudication of the suit, as discussed above. Full stop. Next para. In such view of the matter, we find that in view of the uncontroverted allegations of the husband as proved in his evidence, the appellant husband is entitled to a decree for divorce, if not on desertion, on the ground of cruelty. Full stop. Next para. Accordingly, FAT 264 of 2022 is allowed ex parte, thereby setting aside the impugned judgment and ex parte decree dated February 17, 2018, passed by the learned additional district judge, first court at Shialda, district South 24 Parganas, in matrimonial suit number 227 of 2015. Full stop. A decree of divorce on the ground of cruelty is hereby granted to the plaintiff stroke appellant against the defendant stroke respondent. Full stop. Next para. We stop just a formal decree be drawn up accordingly. Full stop. Interim order, if any, stands vacated. তার নিচে করে নাও, এটা ডিগ্রির পরে হবে, এটা ডিগ্রিতে ঢুকবে না, যা বললাম তারপরে। We intend to observe here that we are just stopping short of making any serious adverse comment against the learned trial judge, merely because such comment would have an adverse effect in the service career of the learned judge. Full stop. However, we expect that the learned judge concerned shall be aware in future about copy-pasting his previous judgments, and in going on his own tangential curve of wishful imagination, instead of adverting to the facts and materials on records in the particular case before him. Full stop. If any future instance of such act on the part of the learned trial judge is noticed, the same may be directed to go into his service book. Yes. Next. এখানে তখন সবকটা কেসে করছে, আমাকে চিনি না করেন না আপনাদের অবজারভেশন। Yes.
When I'm appearing on behalf of the respondent.
Respondent.
Yes.
You are enjoying a divorce degree.
There is an interim.
So not enjoying, but you have a divorce.
Yes.
No appellant, they will give them another chance. Yes, Mr. Kormakar, you are there. Same chamber. Come here into the matter. Yes, where is Mr. Chattopadhyay? You are responsible vicariously for him.
Chattopadhyay, my lord, I'm told that he is just arrived at court. Lord, he was outside. He has just arrived at court. He was there in the other matter. He did not come. Lord, I am informed that he has just
Arrived from where?
But he was from tribunal.
Yes, we'll keep it after the vacation then. What can?
Lordship, then kindly fixes a date if possible.
That will be cruelty to us. None appears for the appellant at the time of call, although the respondent is represented through counsel.
43 and 59.
As a last chance to the appellant to argue the matter, let the same stand adjourned for the day. Last chance has been recorded.
Grateful.
Mr. Kormakar, last chance recorded.
I inform.
Grateful.
Thank you.
Appearance to no none appear.
No, none appears. Okay, আমি মজা করে বলছি।
Item number 42.
Yes, none appears for the parties. Let the matter stand adjourned for the day.
Item number 43.
But 43, my lord, I'll be praying for, my lord, 1 week after vacation.
No, that you have the courtesy of coming and praying for adjournment, that impresses us, and we are granting that. In the other matters, people are not even caring to do that. Who is you? The respondent is you are for the
Yes, yes.
respondent. That's right. On the prayer of the appellant, the matter is adjourned for the day.
1 week after vacation.
Why?
1 week after vacation.
You agree to that? Well, on the prayer of learned counsel for the appellant, we are not recording the agreement. On the prayer of learned counsel for the appellant, let the matter stand adjourned till June 16, 2025.
Obliged.
Item number 44, I am appealing on behalf of the state, my lord, led
Re-
by Mr. Gali.
Respondent.
Yes.
It is a respondent.
Yes.
No, state is the appellant.
I don't respond. I don't.
It is,
Go from state.
You don't even know you are for the respondent or the appellant. You only know you are for the state.
I am just informed by his senior.
Oh no.
Kindly make it short part of pass over, my lord.
Mr. Mr. Who? Shoykot Chatterjee.
My lord, I beg to appear on behalf of the respondent.
Short passover, what do you mean by short passover?
My lord,
You have been praying for short passover since the morning.
my lord, may I
No,
submit?
now you come ready, prepared in your mind. What is your name? Your name. You are Mr. Parthapatin? Sinha. Mr. Sinha, you start arguing matters now. Enough of asking for adjournments. You are
My
for the
lord,
state.
I am for the respondent, private respondent.
Private respondent.
My
Yes.
lord, may I submit? They have filed an application under Order 27,
Order 41,
Order
Rule
41,
27.
Rule 27 for additional.
You want to use an
evidence.
affidavit to that?
Yes,
We'll grant you some time and keep it after 1 week after vacation.
my lord.
Happy? Learned counsel, none appears for the, an adjournment is sought for the appellant at the time of call. Learned counsel for the respondent submits that the respondent seeks to use an opposition to the application under Order 41, Rule 27 of the Code of Civil Procedure filed by the appellant. Accordingly, the respondent is directed to file affidavit in opposition to the said application within June 13, 2025. Reply, if any, shall be filed by June 20, 2025. The appeal shall be listed for hearing next on June 23, 2025, along with the application under Order 14, Rule 27 of the Code of Civil Procedure. Yes. Mr. Chatterjee, train him to start matters.
Yes,
No.
Your Lordship. I
Sufficient
have
adjournments.
already told him that you should start, then I.
Yes. On the next occasion, we'll issue threats against him of dismissal for default and other various other things which we have in our repertoire.
I shall. And my lord, on morning, my lord, that's why I've sent him in item number 1.
Mr. Chatterjee, ensure that he starts. We expect that from chambers like yours.
Lordship.
Ask him to start matters. Yes.
Lordship, I'm good.
Yes. Next one.
My lord, item number 45, I appear for the respondent.
Respondent.
Today also.
We will record his absence. Not a last chance. This is quite down in the list, but we'll
Though they
record
are
it.
enjoying the status quo.
Then we'll record your presence.
Fine.
None appears for the appellant at the time of call, although the respondent is represented through counsel. Let the matter stand adjourned for the day. Please give your names.
Fine.
Yes.
Item number 46.
46, I am appealing on behalf of the state.
Sure.
Yes.
You are also appealing for the state on the last.
In this matter, I am engaged.
Oh, yes.
Matter, I am for the applicant. My
Yes, Mr. Arifin, what is the matter?
lord, by Mr. Chatterjee, my lord, but he has not come to court, my lord.
Why has he not come to court?
Personal difficulty.
What is the personal difficulty?
Personal difficulty. my lord.
Personal difficulty or vacation?
My lord, I have been instructed to, my lord, to pay for time, my lord.
You're granting time, okay. On the prayer of the appellant, the matter is adjourned for the day. Naam bolo
Date
record.
will be fixed, my lord. My lord, after vacation, my lord, any day, my lord, you have to fix the date, my lord. My lord, with that.
Oh, you're asking for time and fixing a date also. Good. Contradiction personified, Mr. Arifin. Give your names, your name for the appellant and your name for whoever is appealing for the respondent with you. আর অর্ডার রেকর্ড করতে পারে না থাকলে নট টুডে
Item number 48.
নট
Item number 49.
49, my lord, I'm for the respondent.
although the respondent is represented to counsel, none appears for the appellant.
My lord, I have not received the copies yet.
Copies of what?
My lord, the appeal.
Paper books?
Yes, my lord.
You have to take from the department then. যে পর্যন্ত বললাম ওই পর্যন্ত, তারপর the matter is adjourned for the day. Give your name.
With regard to that matter, I prefer after.
Although none appears for the appellant, the learned counsel having instruction for the respondents appears in the matter. However, we find from an office report that there is defect in filing of the wakalatnama on behalf of the respondents. Learned counsel for the respondents is requested to cure such defects. The matter be listed on June 16, 2025 under the same heading. In the meantime, please take appropriate a fresh wakalatnama and just alias and all whatever. And
So I take you, tell your lordship, we find there are several mistakes in the record.
Please rectify those.
We have to
Go through the records we have given you to
take appropriate step, my lord.
Acha, learned counsel respondent can take the steps.
No, we have to divulge all these things that will be done by the appellant, because there are so many mistakes since beginning of the suit. That is the defect. It is the duty of the, and we have
that they have to do. We cannot help that. We have kept it on 16th. You can impress if you can impress upon your friend.
Yeah,
you rectify your mistakes first, and
no, then I
you tell your counterpart appearing for the appellant that these are the mistakes. Please rectify. Tell him informally. We are all friends at the bar.
Yes,
just tell him that these are the defects. Please cure.
These are furnishing effect, my lord. That is the defect.
Yes, tell your counterpart.
Then 23rd,
16th June, 1 week after vacation, so that you get some time to contact your client. Granted. On the prayer of the appellant.
Yes, your lordship.
On the prayer of the appellant, the matter is adjourned for the day. Day means after the vacation.
He keeps it after vacation, your lordship.
Day means after vacation. Tomorrow we are sitting singly. But give your name. Only your name, not your senior's name. Yes, next.
I'm for the respondent.
Start the matter. You must be aware of the matter. কিছু order record করতে, not today.
My lord, I'm for the appellants in all the three matters, my lord.
Yes.
I'm for the bank in 54.
My
Right.
lord, I'll be praying to fix the matter 10 days after.
Pray in the microphone so that the bank can hear.
Praying.
Why 10 days?
Because
No,
it's a
10 days I will oppose, my lord, because there is a
All right, 9 days then.
My lord, because Mr. Probal Mukherjee is coming.
Which side?
Senior advocate Mr. Probal Kumar Mukherjee will be coming.
Which side of the world has he gone to?
He said he's going
East, west. Where? If it's east,
London.
we'll keep it shorter.
London.
London is like Darjeeling now.
for him.
For him, yes. Obviously for him. We are speaking in context. Why 10 days after? He'll come back after that period.
Yes, ma'am.
No, then you have to make arrangements because they're suffering.
Mr.
He's
Bennett
there.
is there. Yes.
Start the matter.
No.
What? No.
But Mr.
Not 10 days after vacation.
But only thing because I'm told he's in UK. He will be coming back one week after the vacation.
Let him come back 1 week after the vacation. This matter will be over by then. Your other side is saying that there is urgency. No. Not 1 week.
Then he has no purpose coming back to Kolkata.
This is the only purpose he's coming back to Kolkata.
For this matter.
But kindly keeps it 1 week after vacation. This will be a longish matter. We have to
stay of the proceedings. This is
What is the nature of the proceeding?
Order 7 Rule 11, my lord. This is Order 7 Rule 11. There are 2 suits by my learned friend's client. 1 suit by my client, counterclaim by them.
Then it has been rejected. What
Yes.
has been stayed then?
Claim-
Other suits have been stayed.
In my suit has been stayed because their counterclaim has been rejected.
Oh,
also.
achha.
And all are related to each other.
Yes, Mr. Sen.
The 2003 conveyance challenged in 2000.
You also go somewhere. Come back 1 week after the vacation.
Only thing, lord, I will have no problem. But if your lordship kindly then
No.
because
No fixation.
because the monthly this
Court
will-
cannot be blackmailed due to Mr. Mukherjee. His fault.
then may I say this, my lord? Let it.
If you oppose, we'll keep it before. I mean that.
But-
I will record your opposition. Definitely, you have a right to.
May I say this, my lord? I don't want to sound very harsh to my learned friend.
No, but you have your instructions to follow.
Yes, my lord. But only thing is that if the matter can appear in the list after 9th itself.
No, it will be in the list. It will be in the list.
So let it appear in the list. Let it be understood that we shall do it. Otherwise, problem is, my lord, your lordship follow the sequence. Once it goes down,
yes,
I will not be able to.
No, now our sequence is overtaken by the department's sequence. Whichever way we direct the matters to appear, we cannot have any preference because it's year-wise, it's selected year-wise, and this sequence will not be broken.
So,
but yes, if it goes out of the list and comes back, maybe
then
some.
it will be
You're
difficult.
right. An adjournment is sought for a period of 1 week after the upcoming summer vacation of this court on behalf of the appellant. Full learned senior counsel appearing for the respondent opposes the same and submits that the respondents are suffering from an order of stay. Full stop. Next para. Keeping on balance the respective prayers of the parties, comma, let the matter stand adjourned till after the upcoming summer vacation and be listed in the monthly list of June 2025, which is the first day after vacation.
Well, 9th June will be the monthly list.
9th June will be the monthly list.
But
You're so suspicious, Mr. You have changed.
Judge Sahib.
No, we can't be
Don't
suspicious.
mean
Actually,
you
my lord,
balance
there is a
I
monthly
will-
list coming on Monday or
Yes,
second
that
Monday.
is.
That
We have ensured that by arranging the vacation in such a manner that it reopens on Monday this day.
But I'm obliged, my lord. Lordship has also balanced the adjournment order.
Yes, we do that in our adjournment order. If
Grateful,
contradictory claims are made, there has to be some reason for every order. Every order.
I'm grateful.
well, monthly
Deep
list
level.
also let it, my lord, appear slightly at the top, my lord.
No. Somebody then will go slightly
No,
at the
because, my
bottom.
lord, if by the year sequence we will go.
Whatever sequence is, this will continue in the monthly list. This list, the monthly list is already prepared. Only the ones which are disposed
Then,
of.
my lord, may I say this one? If it may appear in the daily list instead of 9th.
No. It will appear in the list. Whatever appears in the last daily list before the vacation continues in the monthly list. There is no difference between the monthly list and the daily list. And we are telling you, Mr. Shen, from our experience on this bench, monthly list matters are taken up. There's a fair chance of that matter being taken up more in the monthly list.
Very well.
Because on the first day, we tend to take up more matters. I don't know why. But the sequence remains the same. There is no difference between daily list and monthly list in our code.
Very.
No, sorry, yes.
Yes. Next.
Oblige your lord.
Thank you. Yes. You give your name in the inbox. That will be
My
missed
lord.
out.
I'll
Yes.
give it in the inbox.
Yes. Next. Not today. Same. Council আসার আগে তাড়াতাড়ি করে দেখেন not today.
59, my lord, I'm led by Mr. Aniruddha Chatterjee, my lord.
Not today.
My lord,
We are not recording any order, not today.
60. I'm late by.
You're led by?
Injection of order 7.
For the appellant now.
Yes. Now, my lord, my suit has gone. That is the difficulty, my lord. And if a lordship sees it is a
Give us some time to get the because
yes.
we have called so many matters in between. Our target is to able to see counsel to remove so many matters which are as many
Yes.
matters which are necessary for seeing the counsel's face, their expressions and all these things. We are trying to achieve that target first.
But we did not expect that the court will be not, people will not be doing their matters today.
Appeal matters, everybody is
In
for
the motion
benches,
court. Motion court, actually.
People who don't have motions, Mr. Shen, no. We are telling you, who don't have motions, they are also not coming because this has become a status symbol. If they're in this court, that means they don't have any motion.
I can tell you.
You are not status conscious, that's why you are one of the poor persons who are sitting here.
No, my lord, original side, the concept of motion is gone practically.
And Mr. Shen, we are telling you frankly, this bench we are taking up regularly. You are seeing our progress. Application order for turn regularly taken up. So there is no such backlog. Matters have been mentioned, and we are not taking up that. Before the vacation, there will be a rush. Hearing matters, there is no rush in the normal.
Unless
this sort of matters come,
this situation,
or you are appearing. But yes, what is that?
Well, Lord, kindly see the plaint. It starts at page 14. At page
Shaunak Bhattacharya is a regular.
Yes, he's regular.
If you can just, in the meeting, you can start the matter. If he can be called, he can be informed at least that this has been taken up by somebody, your clerk or anyone. I'm not sure where he sits, but no, need not go. You can send your clerk or whoever. You can start the matter so that we can have a hearing, proper hearing. Yes. Plaint rejected.
Yes. Well, I kindly see it is a partition suit. I have prayed for a declaration that we are the joint owners, and for permanent injunction not to create third party interest.
You describe the suit as a declaration.
Declared suit, but actually it is in the nature of
partition has been sought.
No, here there is no partition suit, but here is simply that is my case. Suppose, my lord.
No, you have a right to seek a declaration.
Seek a declaration because if I can possess the property jointly.
Partition is not a further relief.
Yes.
Partition is another relief. You may or may not.
I may not. That cause of action for partition may not have any sense. Because
Permanent injunction
suppose I can coexist with him.
Right.
So therefore, I am seeking.
It has been rejected on that ground.
Yes.
You have not sought for partition.
No, not that. Well, I'll show your lordship. I must be very candid also. Yes. I have also but quite a long time.
Yes, you can come to page 68.
Your lordship will come to the memorandum of appeal. The judgment is there.
So the paper book is with us. Paper book, we are telling you. Paper book, the judgment starts at page 60.
Yes, my lord. Kindly see. Third page. Section 34 has been quoted. Then the 34 of the specific relief.
Yes, we can't find. Order 7 Rule 11 has been quoted here.
Kindly come to page 64. Yes, 64. Kindly see. The learned judge finds in the first paragraph, last sentence, thus from reading of the plaint, it appears that there is cause of action in the plaint.
All right.
Then 34 has been quoted.
Yes, with proviso.
Then page 65, proviso. In the proviso, it has been mentioned that no court shall make any such declaration where the plaintiff being able to seek further relief than a mere declaration omits to do so. In the prayer, plaintiffs only prayed for declaration. Plaintiff was a joint owner of the scheduled property. It is not specified nor prayed for declaration for share of the plaintiff. I need not here, nor in the plaint stated about the respective share of the plaintiff in the suit property. Plaintiff did not pray for partition. I have prayed for injunction. My cause of action is that they are trying to create third party interest and trying to take over my possession. My case is that we are entitled to joint possession. May not be partition. That is my specific case in the plaint. Then, my lord, the various judgments have been referred to, and page 66 it says, to my mind, prayer for declaration is hid by proviso to section 34 of the Specific Relief Act. This is my objection, my lord. And then also the learned judge accepts that these objections were taken orally by the defendants during hearing. The injunction petition did not file any prayer for amendment despite opportunity. What I wanted to say is that, my lord, my cause of action for partition may arise later and does not mean that at the time of seeking declaration, I immediately have to seek partition also. Then, my lord, kindly see page 67. It was argued by the learned advocate for the plaintiff that submission with respect to all consequent reliefs by the learner is not mentioned in, to my mind, even if there is no application with regard to lack of consequence, cannot take the same, and the plaintiff is there a consequence suit is not barred by section 34. Then kindly see, learned judge has gone to section 41H of the Specific Relief Act, injunction when refused. Well,
how is that relevant?
I'm a bit hesitant to say that, but then kindly see there thus prayers of permanent injunction is also barred by law. Why? Well, I could not understand this. Then written statement, they have mentioned that there is already a partition suit pending. Actually, both the suits can be heard together, one after the other.
My lord, these sought for declaration of their co-ownership without seeking share or partition. Why suit is barred?
Has to be, my lord. Kindly comes to, my lord, the paragraph 7, page 7, para 2 of the paper, the plaint.
Yes.
The suit is definitely barred.
Why?
See, my lord, the plaintiffs have become, see, joint owners.
Yes.
Joint owners.
Yes.
In respect of the premises number such and such over a strip of which was amalgamated, dates back long on 10 July 1953 between the and the then joint owners late Chandra Nath Ghosh and Shambhunath Ghosh, and the petitioners herein obtained the same from the ancestors by law of inheritance with co-owners for the sake of brevity and convenience hereinafter, and called the said premises described in schedule of the instant plan. Now, my lord, lordship would then come to, my lord, page 18.
18.
18. Kindly see the documents relied upon. This is they say, my lord, this is compliance of Order 7, Rule 14. Kindly see written complaint and petition under section 142 of CRPC, power of attorney of Ranobhik Ghosh. My lord, prima facie, my lord, there is no document about their co-ownership.
That cannot entail you to a decree of an order of rejection of a plaint. For that, opportunity has to be given.
Ultimately.
Under which provision of Order 7, Rule 11?
No,
show us.
No, they say plaintiffs have become joint ownership. My point is, my lord, before your lordship, is what is their prima facie document of joint ownership to at all entertain this suit?
That is a consideration under Order 7, Rule 11. That is a bar of law.
My lord, bar of law, my lord, kindly see. Ultimately, my lord, kindly.
What is the English of Gatta, Mr. Bhattacharya? Is there in English? There is no counterpart of that sentiment in England, where Mr. Mukherjee is there. That is a ground for rejection of plaint.
It is not
non-disclosure of cause of action. Come to the relevant paragraphs of the plaint. Come to the paragraph shown by para 10, for example.
Yes, kindly.
Sufficient cause of action shown. Court does not say no cause of action. Two grounds. 34 proviso, because share and partition has not been claimed, and permanent injunction is also apparently barred by law. What law?
No, kindly see, my lord. What ultimately, my lord, kindly see prayer E. Prayer E.
At last, you have found out something. Prayer E. A to D, there is no problem. E, yes, E. What about E?
For prohibitory injunction restraining the defendants, their agents and associates from creating an interference in and around the suit premises, along with the and all.
Precisely. Ingress and egress. They are trying to protect their ingress and egress to a property which is a joint ownership property.
No, joint ownership, not prima facie without.
What is the bar of law? It is barred under which law?
First, my lord, partition has not been claimed. Joint ownership.
What else? You heard the appeal. Past judgment.
This is the Millard. That was my submission, Millard. If Millard, they cannot show Millard prima facie document, Millard. This is.
We'll record this submission of yours and send a copy to the chairman of the Human Rights Commission. Yes, let us do that. We'll just record the submission and just send a copy and direct in the order, judgment itself. A copy to be sent to him.
Immediate.
That prima facie case, no prima facie case has been shown in this.
The immediate predecessor is sitting here itself.
Who?
Code number 6.
Yes, first him. No, he's much more. I mean, he'll be much more gentle.
Yes, but I forgot in a matter. Both of us are appearing. Why isn't the matter here? It is a relational matter. Then I realized that
yes.
cannot be.
We are passing judgment. And we'll record you that submission of yours also. But we'll not send it anywhere. Learned, the present appeal has been preferred against a judgment and deemed decree whereby the plaint of the appellant has been rejected. Full stop. The suit was filed primarily for a decree of declaration that the plaintiffs are the joint co-owners of the scheduled properties, comma, a permanent injunction restraining the defendants from transferring, alienating, and or creating third-party interest, and for permanent injunction restraining the defendants from creating any hindrance to the peaceful enjoyment by the plaintiffs in their present occupation with the common boundary wall in respect of the suit property. Full stop. Next para. Learned senior counsel appearing for the appellants argues that the learned trial judge committed an error of law in holding that the suit is barred by the proviso to section 34 of the Specific Relief Act 1963, as no separate declaration regarding the shares of the plaintiffs as well as no relief for partition has been sought in the suit. Full stop. Furthermore, comma, the learned trial judge observed that even the prayer for permanent injunction is barred by law merely by quoting the relevant provision under section 41 within bracket small h of the Specific Relief Act without giving any reason as to why there was a bar under the said provision. Full stop. Next para. It is accordingly contended that the impugned judgment and decree is vitiated by palpable error of law and ought to be set aside. Full stop. Next para. Learned counsel appearing for the defendant's respondent submits that no prima facie case in support of the plaint contentions have been disclosed in the plaint. Full stop. Furthermore, comma, the documents enclosed with the plaint are insufficient to establish the plaint case. Full stop. Next para. Learned counsel for the defendant's respondents reiterates the observations of the learned trial judge by arguing that in the absence of any prayer for partition, comma, the suit is bad for violation for contravention of section 34 within bracket the section 34 comma proviso of the Specific Relief Act 1963. Full stop. Next para. Upon hearing learned counsel for the parties, comma, we find that the impugned judgment and decree are not tenable in the eye of law for the following reasons. Full stop. Next para. Section Section 34 of the Specific Relief Act provides that any person entitled to any legal character or to any right as to property may institute a suit against any person denying or interested to deny his title to such character or right, comma, and the court may in its discretion make therein a declaration that he is so entitled, comma, and the plaintiff need not in such suit ask for any further relief. Full stop. However, comma, by way of an exception thereto, comma, the proviso carved out in the said section stipulates that no court shall make any such declaration where the plaintiff, comma, being able to seek further relief than a mere declaration of title, comma, omits to do so. Full stop. Read in conjunction, comma, whereas a plaint is very much maintainable if a declaratory relief is sought without seeking any further relief, comma, the only exception being where the plaintiff is able to seek a further relief than a mere declaration of title but omits to do so. Full stop. Next para. In order to ascertain the applicability of the proviso to section 34, comma, we are to look at the relief sought in the plaint. Full stop. Next para. We find that the premise of the plaintiff's case is that the plaintiffs are co-owners of the suit property and the defendants are seeking to create third-party interest to the property as well as to disturb the peaceful enjoyment of the plaintiffs in respect of the suit property. Full stop. In paragraph numbers 6, 6, 7, 9, 10, 9 and 10 in particular, we find that a strong case giving rise to the cause of action for instituting the suit has been made out. Full stop. Next para, thus, in consonance with the findings of the trial court itself, we find that sufficient cause of action has been disclosed in the plaint. Full stop. Insofar as the relief of partition is concerned, the same is not within double inverted further relief, double inverted close, but an double inverted other relief insofar as the declaratory relief is concerned. Full stop. Partition is not a necessary adjunct of a relief of declaration and is an independent and other relief which can be sought if cause of action for such relief arises. Full stop. Next para, it may very well be that a co-owner of a property, if his or her title to the property is threatened, may file a suit for declaration of such co-ownership simpliciter, seeking consequential necessary relief by way of permanent injunction, which has precisely been done by the plaintiff's appellants in the present case. Full stop. It may also be that such a co-owner of the property may not intend to have a partition of the property, but want to continue and perpetuate the joint possession of the property. Full stop. As per the plaint case, the plaintiffs are not aggrieved by the refusal of the defendants to part ways by having a partition, but only with the perceived action of the defendants in threatening the possession and enjoyment of the property by the plaintiffs, as well as in trying to create third-party interests in respect of the property and changing the nature and character thereof. Full stop. Thus, as per the cause of action disclosed in the plaint, declaration of co-ownership with the consequential relief of permanent injunction is sufficient to meet the requirements of section 34 read with its proviso. Full stop. In the present context, there is no necessity to seek any further relief of specific declaration of shares of the plaintiffs and or partition, since no cause of action has arisen therefore. Full stop. Next para. Thus, the finding of the learned trial judge to the effect that the suit is barred by the proviso to section 34 of the specific relief act is, on the face of it, erroneous in law. Full stop. Insofar as the bar to the relief of permanent injunction is concerned, not a single line of reasoning has been attributed for coming to such conclusion by the learned trial judge. Full stop. The learned trial judge merely quoted section 41 within brackets small h of the specific relief act, which provides in subclause small h that when equally efficacious relief can certainly be obtained by any other usual mode of proceeding, except in case of breach of trust, permanent injunction shall be refused. Full stop. However, neither the learned trial judge enumerates as to what could be the equally efficacious relief to substitute injunction in the present case, nor do we find any such alternative efficacious relief to substitute the relief of the remedy of injunction. Full stop. Hence, such finding of the learned trial judge is also bad in law. Full stop. Next para. As such, the impugned judgment is vitiated by palpable errors of law and ought to be set aside. Full stop. Accordingly, FAT 203 of 2024 is allowed on contest, thereby setting aside the impugned judgment and deemed decree dated June 29, 2024, passed by the learned judge, 10th bench, City Civil Court at Calcutta, entitled suit number 1296 of 2022, thereby remanding the matter to the learned trial judge for full-fledged adjudication of the suit on trial upon taking evidence of the parties and granting adequate opportunity to the parties to adduce such evidence and advance their arguments on the merits of the suit.
On that day, there was an injunction application and appointment of receiver application also. So those will be directed to be considered.
The learned trial
And
judge.
only one thing, my lord, on that day, my lord, there was an interim order of status quo passed by this court, which was continuing to be taken up by the learned trial court to be decided subject to the injunction application. Instead of injunction application, order 7 rule 11 was taken up. So my lord, your lordship will kindly continue the order of status quo passed by this court.
Did this court continue that injunction till the disposal of the injunction?
Yes, it said parties, kindly take page 38 of the paper book. 38 at page 40. It said, in the meantime, parties shall maintain status quo with regard to occupation and dealing with the property, including creation of entrapment, which shall abide by the order to be passed by the learned court.
আচ্ছা next para করে দাও.
This is not in this appeal.
No, not in this appeal. This is recorded in the impugned judgment also. If you see the impugned judgment, we found a cursory mention of this FMAT, page 68.
Yes. Page 68.
See that? Page 68, the last paragraph, Mr. Bhattacharya, you'll find it.
Yes.
It is recorded there.
It was against the refusal of ex parte injunction.
See the last paragraph?
Yes.
It is also pointed out, we also find from the impugned judgment itself that there was a subsisting order of status quo granted by a coordinate bench of this court till disposal of the application for injunction and applications for injunction and receiver pending in the learned trial judge. Full stop. Since we remand the matter, we restore the said status quo order and request the learned trial judge to dispose of the injunction application and receiver application pending in connection with the suit as expeditiously as possible, preferably within 1 month from the date of communication of this order to the learned trial judge.
Obliged.
অনেকদিন ডিক্রি হবে না রিমান্ড করে জাজমেন্ট একদম ফুল ফেজেড জাজমেন্ট.
Obliged.
থ্যাংক ইউ. ফর্মাল ডিগ্রিটা শুধু ড্রন অফ হবে না যেহেতু রিমান্ড করলো. আপনি যে বলছেন তাই হচ্ছে.
16 I am for the appellant, but
not এমনি not same.
I'm for the appellant.
63. Thought matter, we can start then.
But the respondent is not here, my lord.
We'll record your presence that the respondent was there. We'll just.
A book has been submitted, has been handed over to them. It is filed on time.
Although this is item 63, although the appellant is represented through learned counsel, none appears for the respondent at the time of call. Full stop. Accordingly, let the matter stand adjourned for the day. For the day means after the week. Please give your names. Thanks. Next.
Your Lordship, on behalf of the appellant, I am praying for not today.
Not today. Just order record. Not today. Not today. Order show Not today. Same.
67, my lord, I am for the appellant, my lord. I have two small submission, my lord. On the last occasion, during this is an appeal in a partition suit. Order 40 application was turned down, my lord. On the last occasion, Lordship directed to serve copy upon the respondent number 1. I have served. Evidence of service is 5, my lord. During pendency of the instant partition suit in the trial court, my lord, we have filed one application under Order 1, Rule 10(2). That application was allowed and 3 parties were added. That parties were not added in this proceeding, my lord. That they may be added, or I may be liberty be granted to me to file an application.
File a 1-page, 2-page application.
And another is, my lord, there was a direction to file upon me to file a reply, my lord. That we could not file because my
to what?
To the opposition filed by the respondent, my lord.
Opposition to what? Your interlocutory application here?
There is a CAN application.
You served a copy of the CAN application only, or
No,
what?
no. They have appeared, my lord.
Yes, Mr. Bose appeared.
Yes. Opposition they have filed.
Acha.
They have filed their
You want
opposition.
an extension of the time to
file reply and
affidavit of service filed today be kept on record. Full stop. None appears for the respondents at the time of call. Full stop. On the prayer of learned counsel for the appellant, the time for filing reply in respect of the CAN 1 of 2024 is extended till June 13, 2025. Full stop.
my lord, 1 week after vacation.
That is June 13th. Next para. On the further prayer of learned counsel for the appellant, leave is granted to the appellant to file an appropriate application for addition of the parties who are impleaded in the suit from which the present miscellaneous appeal arises. Such application shall be filed also within June 13, 2025. Liberty to the appellant to mention the application for inclusion in the list along with the appeal as and when filed.
Grateful.
Should we direct the appeal to appear as under the heading application then? Acha, let the matter appear under the heading application on June 16, 2025. এটা application heading এ চলে যাবে.
Can it be on 17 June?
Yes, তাহলে June 16 না করে 17 করে দাও.
Grateful.
June 17.
Hello, 68. I am for the appellant, Mr. Sagar Bandyopadhyay, appearing this matter. My lord.
Make it not today, after the
After vacation, my lord, the matter is long run today. My lord, if the part had otherwise,
not. Same. Grateful.
For the respondent.
Let's just make it
Not today, man.
10. Not today. By default, not today. Call করে দেন.
75 Lord Mr. Kushal Chatterjee is appearing for the appellants. Not due to some personal inconveniences, he is not.
Appellant is not there. We are granting adjournment.
My lord, item number 74, I'm appearing for the appellant, my lord. I'm humbly seeking an opportunity.
No, the humility is misplaced because we have already adjourned.
Grateful, my lord.
75 also not today. Not today. By default, not today. By default, not today. If somebody appears, we'll take up the matter. Yes.
Grateful.
For the appellant led by Mr. Bhattacharya.
This is for the other side.
We have affidavit of service.
And কেউ নেই আর কি
No,
করবি
that's the record. Affidavit of service also.
আচ্ছা একটা order record করে affidavit of service filed today be kept on record.
77.
Yes.
I'm for the respondent.
Then we can hear them.
Madam, I took to it the please.
Affidavit of service filed today be kept on record. On the prayer of the respondent, let the matter stand adjourned for the day. Means after vacation.
Yes.
Mr. Bhattacharya was also of the same view, but his learned assisting advocate was not happy.
Grateful, my lord.
Next. Not today. 10.
Lordship, I appear on behalf of the appellant. I'm being led by Mr. Datta.
They are granted. Yes. Not today.
Thank you, husband.
For the response, I'm so sorry, but 86 is my appeal. But it's a challenge to an ad interim order. By
give some time to them to find out the file because so
File.
many matters have been called. Give some time.
Yes.
Order 41 গুলো একটু sort out করুন 80. You are in 85.
86, my lord, 86.
87. You are for the respondent. The appellants are not there. So let us see. We know that. Let us wait for some time. Let this matter be over. You stay on.
86.
86 there. Is there any caveat in your matter?
No, there's no caveat. Well, it was taken up on an earlier occasion where your lordship indicated if after your lordship admits the appeal, then I'll serve. But I've not served yet on the respondent plane.
Right.
When my brief has not come, but I'll indicate the matter to your lordship. There's some urgency.
Our brief had also not come. Not now it has. As your brief has come also.
This is Mr. Sengupta's brief who's
Is
leading.
Mr. Roy trying to influence you in any undue influence?
No,
Just complain to us.
Not at all. Not at all.
Yes.
That here, my lord, challenging an order of injunction, it's stay on a notice issued by me. I am the landlord of a particular unit which is under a shopping complex. But the unit, the lessee, runs a diagnostic center from there. But there is an agreement for lease, unregistered agreement. There is a separate agreement for putting up a signboard of the particular lessee. It runs a diagnostic center under the rules. He is permitted to do so. The issue here is that he has put up a signboard and on the outer wall of the shopping complex. But our contention is that the signboard is not safe for the public at large. There are lot of people coming in the shopping complex. There are other shops as well. In the manner in which the signboard has been put up, it can fall anytime. But this is the only issue involved in the suit as well as in the appeal.
The injunction is from restraining you from giving effect to the notice. Notice is what?
Notice is I had issued the notice asking him to repair and affix it with the wall so that there is no safety issues. So that the signboard can.
Any warning clause there in default?
No, in default, I have indicated in default we will have no other option but to terminate. But we have not terminated yet. The lease is still there.
The injunction is not to give effect to the notice without due process of law.
Yes, but I'll show your lordship the notice. The notice does not say that we are terminating. The notice says that please rectify, please affix it with.
Shows the notice, yes.
Thank you.
Two notices,
Two
19.2
notices.
and 10.3.
Yes, my lord. If your lordship takes page 147, which is the 10th March notice.
Yes.
This is our notice. Kindly seize the penultimate paragraph. Kindly take paragraph 8, page 153.
Yes.
In view thereof, until and unless the said advertisement board is fixed in accordance with the agreed terms forthwith, my client will have no other option other than to terminate the said agreement dated so and so, and to dismantle. So, I have not terminated the lease.
Agreement terminate করার থেকে তো সেটা কি করে injunction কি করে terminate তো করতে পারে সেটা তারপর legally ও তো বলেনি তুমি বেরিয়ে যেতে. And what is the other notice?
But the other notice also says the same thing. I'll indicate.
Just show us.
Yes.
You never know, there
page
may be
1. I'm
something.
sorry. Page 136. The subject says notice of termination, but your lordship will kindly take the last paragraph, page 138. In the above context, you are again hereby requested to install the said advertisement by fixing it to the wall, identical to the other advertisement board already fixed within 7 days, failing which we will have no other, any other option, alternative other than to terminate the agreement.
Yes, take করে দিচ্ছি কারণ এটা injunction দিতে পারে.
But may I only say there is another aspect with respect to the order. The order also restrains me from
Disconnection of electricity.
disconnection of electricity.
Disconnection will.
But I understand. I understand. But
That
the
we are also thinking.
Yes, but the only issue is if the plaintiff or the respondent in the
The
appeal.
order says without due process of law and or from disconnection on payment of requisite monthly rent.
Yes, that the lessee is
That
also not
part
saying
is-
that he'll not pay. The lordship understands if this is an ego battle between the lessor
No,
and
but
the
it is also it also states and or dismantling the glow signboard.
that there is no threat to that. We are not
So these
dismantling
two parts were not disturbing, but we'll stay the portion where you will not give effect to the notice.
My lord. But if a lordship also observes this much, so that the issue can be resolved between the
If
parties.
they appeared, we could have disposed of the appeal itself.
Yes. If your lordship makes it returnable anytime soon, I'll serve this issue can be resolved. It's only that the signboard is hanging from the wall. If it is affixed to the wall, we'll have no other issue.
What is your suit for?
The suit is for declaration that he is entitled to put up the signboard and under the separate signboard agreement, and that he is entitled to electricity.
The present appeal arises out of the grant of ad interim injunction in favor of the defendant respondent in a suit filed by the latter, defendant's respondents in a suit filed by the latter for declaration of their rights in respect of a lease agreement between the parties and for protective orders ancillary thereto. Full stop. Next para. Learned counsel for the appellant points out that by the impugned order, the learned trial judge has restrained the defendant number 1 stroke appellant from giving effect to 2 notices respectively dated February 19, 2025 and March 10, 2025 without due process of law and or from disconnection of electricity supply to the glow signboard on payment of requisite monthly rent by the plaintiff and stroke or from dismantling the glow signboard of the plaintiff till May 6, 2025. Full stop. Learned counsel for the appellant submits that the notices in question merely indicated that in the event the proper affixation of the glow signboards as mentioned therein is not done by the plaintiffs stroke respondents, the agreement between the parties would be terminated by the appellant. Full stop. Next para, it is contended that although although there is no present intention on the part of the appellant to disconnect the electricity supply subject to payment of rent by the respondents and or from dismantling the glow signboard immediately, in the event the appellant is injuncted from giving effect to the notice, the same would tantamount to decreeing the suit before it is decided. Of that apart, it is submitted that the said notices, although captioned as notice of termination, does not purport to terminate the juror relationship between the parties immediately, but give an option to the respondents to comply with the directions therein in terms of the agreement between the parties, and only in default, that steps for termination of the juror relationship of lesser lessee shall be taken. Who's the next para? We find substance in the contention of the appellant, inasmuch as the learned trial judge ought not to have granted injunction restraining the defendant number 1 stroke appellant from giving effect to the notice, in view of the said notices being merely prior warning to the plaintiff stroke respondents to comply with the terms of the agreement between the parties and warning the plaintiffs that in the event the terms were not complied with, the juror relationship between the parties and the agreement would be terminated. Full stop. Next para. The court cannot grant an injunction in respect of contracts which by their very nature are terminable. Full stop. Next para. Although it is always open to the plaintiffs to challenge any future termination, if effected by the appellant, the mere notice asking the plaintiffs to comply with the terms of the agreement and threat of future termination cannot be construed to be a present termination for the purpose of grant of injunction. Accordingly, we admit the appeal for being heard on the grounds as taken in the memorandum. Next para. There shall be stay of operation of the impugned order dated March 21, 2025 to the limited extent that the defendant number 1 stroke appellant and his men and agents have been restrained from giving effect to the notices dated February 19, 2025 and March 10, 2025. Full stop. It is made clear that the other part of the impugned order, whereby the defendant number 1 stroke appellant has been restrained from disconnecting the electricity supply to the glow signboard of the plaintiffs on payment of requisite monthly rent by the plaintiffs and stroke or from dismantling the glow signboard of the plaintiffs till May 6, 2025, are not interfered with or stayed. Full stop. Next para. The above limited order of stay granted by us shall continue till June 30, 2025 or until further order, whichever is earlier, full stop. The appellant shall serve copies of the memorandum of appeal and the application on the respondents, indicating that the application shall next be listed on June 23, 2025, June 16, 2025, under the heading applications, full stop. Affidavit in opposition, if any, no, June 23 করে দাও returnable date. June 23, 2025. Affidavit in opposition, if any, shall be filed by June 13, 2025. Push of reply thereto shall be filed by June 20, 2025. যেটা interim order দিয়েছি না তখন ওটা June 30 পর্যন্ত করেছি তো ওটা till July 15, 2025. Interim order till July 15 to that limited extent. Affidavit by 13th June, 20th June reply, 23rd it will appear.
May I make one prayer? Well, let these directions be there. But if your lordship is
আর একটা line, affidavit of service shall be filed on the next returnable date by the appellant. Yes.
But if your lordship kindly keeps the matter, but at any time, as soon as the court reopens, but the issue is very small. If they can appear and we can resolve the issue insofar as the affixation of signboard is concerned, the affidavits are not required. But since your lordship has passed the direction,
You'll serve copies immediately. If
Well,
there's a chance of resolution, you exclude that. You can mention even earlier. If there's a resolution, you can mention anytime and we'll put this to you.
Well, I'm led by Mr. Shengupta. Lordship will kindly grant me leave to.
Purpose of.
Anyways, your lordship, I have to then give the electricity to the globe board, which is your lordship in.
Electricity, we have not interfered for the present. Electricity you will give and you will not evict. No, the other part of the order.
Eviction, your lordship.
Not
actually.
eviction. The other part of the that we have.
Yes.
We have had a discussion with your learned junior, and we agreed on that.
I'm grateful, your lordship.
Yes.
I beg to appeal for the appellant, my lord. And my lord, unfortunately, my lord, my advocate on record is not here today. He is having the original supplementary affidavit, which my lord has directed on last occasion. Can it be tomorrow, my lord? Tomorrow, my lord takes up.
It cannot be tomorrow because it sits singly.
Singly, my lord. I know that, my lord.
An adjournment is sought by the appellant.
Well, we have been served.
I have served them, my lord.
Full stop. Accordingly, let the matter stand adjourned till after the upcoming summer vacation.
Let it be on 9th, my lord. Let it be on
My lord,
what is the first day after
9th, my lord.
It will appear on that date.
My lord. Sorry, my lord, my lord.
Yes. নামগুলো record করবেন. Only your name and all their names.
My lord, definitely.
I'm grateful, lordship, and happy holidays.
Yes,
Same from my end, my lord.
Same to you, from both of us.
18th lordship, I am for the appellant.
Yes, at last your matter has come. Yes, let us dismiss it. You're disturbing others while sitting there.
No, I was.
There is no caveat, Mr.
No,
Yes,
no
what is it?
caveat, lordship. Suit for partition and injunction, lordship.
Yes.
Suit for partition and injunction along with the.
What is the defect?
We have removed the defect. The name of the learned judge was not appearing. We have done it, lordship.
Yes, sorry, please continue. Partition suit.
Partition suit, lordship.
Your suit.
My suit, lordship.
Injunction refused.
Yes, ad interim order has been refused, lordship.
Why?
Lordship, I'm telling you, lordship. Suit for partition and injunction was filed. And injunction order was rejected. We moved this honorable court. And your lordship will kindly find at page 42, this honorable court allowed the injunction application directing the parties to maintain status quo and in respect of nature and character and restraining them from making any further construction, the defendants, opposite parties. Now, your lordship, thereafter they have filed an application under order 7 rule 11. That was allowed. Again, we came up before this honorable court. This honorable court rejected the application under
So
order
this
7.
court granted injunction, that status quo, till disposal of the temporary injunction application.
Till disposal of the suit. Earlier suit. I'm taking up.
There's an earlier.
Yes. Now what has happened, lordship? In this course of time, lordship, the record has been destroyed.
No, the previous suit, what happened then to the 711 was filed in the previous suit.
Previous suit, it was allowed. We came up before this honorable court. Appeal was allowed.
Suit was restored.
Suit was restored. Now, your lordship, thereafter, the entire record has been destroyed. And taking advantage of that situation, lordship, they are carrying on selling the properties and carrying on construction. Your lordship will kindly see the information sheet we have obtained.
So you filed a fresh partition suit.
Yes.
Previous one was also a partition suit.
Yes.
It's a continuing cause of action.
Yes, yes. Now, your lordship will kindly come to page 60. This is the information slip. order sheet are completely in torn condition. Therefore, I cannot.
Then the records are not destroyed. Order sheet in torn condition is something else.
Entire thing is
The
destroyed.
other records are there.
But we cannot file anything, Lordship.
But is a new suit maintainable? That suit is pending. This is barred under section 10.
Lordship, res judicata, Lordship, if there is sub judice.
Not.
That is, it is not, it is sub judice.
Section 10, not res judicata.
Stay. Stay.
If a similar suit is pending.
Yes.
This is a subsequent suit.
But Lordship, we have no other relief, Lordship. Because unless and until.
Which page is that information slip?
Yes, page 60, annexure D. I will be remediless because nothing is happening in that suit.
But the suit is pending, Mr. Rai.
Pending.
You should have made an application.
That we have
Injunction is
brought
still there.
reconstruction. That was also not taken up.
In that suit, the injunction notice is subsisting.
But we think there is.
We must have a certified copy of the order of this court. Of this
we have, yeah, we have.
Then we have a status quo. Where is the scope of another suit being filed?
Because Lordship, we are
So ask for
getting
reconstruction of the records. Why remediless? You have an injunction already in your favor.
But reconstruction is not happening, Lordship.
Even then, it's in your benefit. Because your partition suit is pending, you are enjoying the status quo. So what is the occasion of further status quo, further suit? Reconstruction is not happening, then every matter where reconstruction does not happen, one will file a new suit. No, not maintainable. So you actually have to dismiss your appeal.
No, that is one thing, Lordship. But
we'll say that you're remedializing the other suit. You seek reconstruction there, and also we'll observe that your status quo order granted by this court is still subsisting.
Yes.
Just show us that that order.
Page 41, Lordship.
We'll observe in our order that since that order is already subsisting, there is no scope of granting any further relief on the self-same grounds. That is subsisting. That is not disposed of.
No, it is not.
Therefore, you have an injunction in your favor. Why seek?
My favor, Lordship. But because of the record is in a destroyed state, court is kindly direct the court to that extent.
In this suit?
No.
We are taking up an appeal against this. That is the difficulty. We'll give you liberty to take steps before the concerned district judge, the administrative head of that district. Which district? Alipur?
No, Barashat.
Barashat. Not. Very well.
Page 41, Lordship. The legality and priority of the said order passed
yes,
by the...
Yes, by restraining both parties. Page 42 is the...
Yes.
The present appeal has been preferred against an order refusing ad interim injunction at the behest of the plaintiff stroke appellant. First up, the counsel for the plaintiff appellant submits that previously a partition suit was filed by the appellants in which initially temporary injunction was refused by the learned trial judge. Full stop. Having come up in appeal against the said order, the appellate court disposed of the said appeal bearing FMA number 592 of 2015, thereby directing the parties to maintain status quo as regards nature and character of the suit property till disposal of the partition suit, as well as by restraining both parties from raising any construction and stroke or further construction over the suit property and or from changing the nature and character thereof till the disposal of the suit. Next para, the parties were also directed to maintain status quo with regard to their possession in the suit property till the disposal of the suit. Next para, thereafter, learned counsel for the appellant submits, the records of the said suit were completely destroyed, by relying on an information slip annexed at page 60 of the injunction application filed in the present appeal, it is pointed out that the order sheets of the suit bearing title suit number 313 of 2012 are in completely torn condition, although the suit is still pending. It is submitted that the appellants are facing a situation where they have an existing suit, but they cannot press for the remedy in the absence of the records of the said suit. Being thus compelled, a fresh partition suit has been filed in connection with the present injunction was sought. Next para, upon perusal of the impugned order, we find that the same is vitiated by lack of reasons. However, we are unable to interfere for other reasons as enumerated below. Next para, whatever might be the present condition of the records of title suit number 313 of 2012, comma, the said partition suit on the self-same cause of action on the strength of the same right title and interest of the parties as claimed in the present is still pending. Full stop. Although the order sheets of the same are completely in torn condition as per the information slip produced before us, comma, there is nothing to show that the records have been otherwise destroyed. Full stop. In any event, comma, it is always open for the parties to the said suit to approach the concerned court and stroke or the learned district judge having administrative supremacy in the concerned district, that is the district of North 24 Parganas, for taking appropriate steps for reconstruction of the records and or tracing the file of the case. Push up next para, be that as it may, comma, in the teeth of the pendency of the previous partition suit, comma, the principle of section 10 of the Code of Civil Procedure applies and the second suit is prima facie barred. Full stop. That apart, comma, we find from the judgment and order dated March 3, 2016, passed in FMA 592 of 2015, comma, which arose out of title suit number 313 of 2012, comma, that the said status quo order is still subsisting. Full stop. Thus, comma, the reliefs sought in the present injunction application in the second suit are or have already been granted and are subsisting in favor of the appellants in connection with the previous suit bearing title suit number 313 of 2012, comma, thus denuding the appellants from any cause of action for seeking further injunction on the self-same grounds. Full stop. Hence, comma, we do not find any reason to interfere with the impugned order, comma, although we are not happy with the sufficiency of the reasons attributed therein, but since we agree with the conclusion thereof. Full stop. Accordingly, comma, in the light of the observations made above, comma, FMAT 154 of 2025 is dismissed under order for turn rule 11 of the Code of Civil Procedure. Full stop. Consequentially, can 1 of 2025 is also disposed of. There will be no rest to cost. It is made clear that the merits of the respective contentions of the parties in the present suit or in the previous suit have been decided by us, and it will be open to the learned trial judge to decide the said suits on their own merits.
I'm grateful to you.
So that there is not an affirmance, we have dismissed it under order for turn
Yes.
rule. But these
And-
findings will be there.
And we have already stated that we have already applied for the
You
reconstruction.
are enjoying an status quo order already.
But we cannot get the benefit of that injunction order because there is no.
Throw the certified copy in the face of anybody who is violating, and also to the police authorities.
Lordship. Grateful to you.
Not today. 90 হয়ে গেছে 91 not today 91 not today. We are not passing any further orders because we'll already take till night to sign the not today orders. 10 not today. Appellant 94, there is no caveat.
Suit for what?
Suit for?
Suit for partition. Ad interim refuse, kindly see the impugned order.
Other matters we are releasing. Other matters are released.
Item number 85.
This is 80.
My lord, it was passed over. I was in 652. I came running.
After vacation, after vacation. This matter will take some time, yes. We have only 8 minutes left.
But if my lord kindly takes up that matter only. Very well, my lord. Very well. Great.
Yes. What is the matter?
My lord,
Hey, ye dekhe na. Yes.
impugned order, my lord, last portion, my lord.
This is a suit for what?
Partition, my lord.
Partition suit?
Ad interim refuse, my lord. My lord, Observe.
What document have you filed? Document of
My lord,
title?
I have filed the equal document. My lord, your lordship kindly.
No, it says that your predecessor's title deed
But I
has
have filed the tax bill and I have also filed the death certificate. My lord, I have
claimed by inheritance.
inheritance.
But
I also the Fariaz Nama, my lord. It's a Muslim property, my lord. My lord, if your lordship take the injunction application, my lord.
Yes, which page is the Fariaz Nama?
My lord, first of all, my lord, I am showing the list of documents, page 13 of the plaint. My lord, page 13 of the injunction application. Page 19, my lord. May I correct myself? My lord, list of documents, number 1, Aadhaar card, death certificate of Muhammad.
What is the Fayaz Nama?
My lord, Fayaz Nama is page, item number 4, my lord. Dated 12/1/2025.
Where is it annexed?
My lord, it is annexed at page 43, my lord.
This is made by the Qazi?
My lord, Qazi, my lord, Muhammad. Qazi.
Not, yes,
But I am Muhammad.
Yes, at the end, Muhammad Sarfuddin Ahmed, Muhammad Register and Qazi. That has been obliterated. Faraz Nama is generally done by them.
And I have also annexed the tax bill, which itself bears my name, also the name of the defendant.
What sort of injunction?
My lord,
Nature character? Nature character. Illegal construction is covered by nature character and third party interest. The present appeal has been preferred against an order of refusal of ad interim injunction in connection with a partition suit filed by the plaintiff. Full stop. The learned trial judge refused such ad interim injunction only on the ground that despite having filed Aadhaar card and other documents, Aadhaar card, power of attorney and other documents, no document of title of the predecessor of the plaintiff has been filed. Full stop. Next para. However, we find from the annexures to the injunction application, which were also annexed to the plaint and the injunction application in the trial court, that a Fayaznama dated January 12, 2025, indicating the lineage of the predecessor in interest of the plaintiff has been filed along with several other documents to indicate circumstantially the right title and interest of the plaintiff appellant in respect of the suit property sufficient to give rise to a prima facie case for grant of injunction. Full stop. Accordingly, we admit the appeal to be heard on the grounds as taken in the memorandum of appeal. Full stop. The respondents and their men and agents shall remain restrained by an order of injunction from changing the nature and character of the suit property in any manner and or from creating any third party interest in respect of the suit property, till disposal of the present application. Full stop. The appellant shall serve copies of the application on the respondents, indicating that the application shall next be listed for hearing on June 16, 2025, when an affidavit of service to that effect shall be filed by the appellants. By the appellants. Yes. Thank you.